The Senate Judiciary Committee will come to order. The clerk will call the roll. I don't know if we have a quorum.
Mr. Chair, you have a quorum?
Barely. Oh, maybe some people will show up. Senator Steph, is he here? He wanted to go first. Okay. We'll go on to the next person is, is he here? Yeah, Adam, would you like to go next?
Yes, thank you.
Good. Before that, let me tell everybody that Senator Chase has COVID, will not be here, and ask that her bills go by. Senate Bill 805 and Senate Bill 1488 will go by for the day, okay? And also, Senator Sudeline has a bill 1433. He wants to go by for the day as well, okay? Senator Evans.
Thank you. This is Senate Bill 1181, the ghost gun ban, creating a Class 1 misdemeanor punishable as a Class 4 felony for a second or subsequent offense, making it unlawful to knowingly possess or transfer or purchase an unfinished frame or receiver unless it has a serial number or the party's a federal firearms importer, manufacturer, or dealer who can serialize it. The provisions relating to I should say what we're doing is we're fixing a loophole. Manufacturers are required to put a serial number on finished firearms, but not on individual parts. And if it's not serialized under federal law, you couldn't buy it in Virginia, and that's how it should be. So everything else is really a loophole, and that's what we're trying to correct. We know that ghost guns include all the necessary component parts to turn the unfinished frame or receiver into a fully functioning gun that looks, feels, and functions like a traditional gun, whether a handgun or an assault-style weapon, and can be just as deadly and dangerous in the wrong hands. Ghost guns have been used in a series of horrific mass shootings, and I'll just mention two of them. In 2017, a man under prosecution for multiple crimes killed 6 people and injured 10 in California with 2 assault-style rifles he assembled using parts ordered online. And in late 2019, a 16-year-old used a ghost gun to kill 2 students and injure 3 others at Saugus High School in California. He, too, was too young to legally purchase a gun. These weapons are attractive to organized crimes for many reasons, with the ease of obtaining and untraceability being high on the list. The measures in this bill support legitimate gun sellers who can lose business to those selling these parts and kits, which are marketed as unregulated and untraceable. The bill is about keeping guns out of the hands of people who are prohibited purchasers and traffickers.
Mr. Chair.
Senator Deeds.
Senator Evans, this is similar to a bill you had last year. There are some differences, and maybe you could explain those differences.
You know, I don't have a side-by-side of the differences. We made this one a little bit simpler. I don't know if council is familiar with last year's bill, or if any of my witnesses could. Tanya Sharp from Brady could explain a little bit.
Thank you so much. Good morning, everybody. Tanya Sharp from Brady. This is a really simplified version of the bill. It simply intends to target the sale of these parts that are intentionally intended to circumvent federal law. So it's really just prohibiting the sale of these parts. If they're not serialized pursuant to federal law, you simply can't buy them.
Okay. Well, Mr. Chair,
Senator
I was
Deeds.
just wondering, because last year's bill included a reference to plastic firearms. That's gone from this year's bill?
Yes.
Okay.
You want me to stay here?
Any questions of the patron? Is anybody who'd like to speak for the bill?
If any Zoom participants would like to speak in support of this bill, please raise your hand electronically.
Again, Tanya Sharp for Brady. Just to clarify further, ghost guns circumvent or undermine almost every state and federal gun law, including background checks, and undermine law enforcement. And in the past several years, we've seen the implications of this. The federal rule provided some strong protections against the continued proliferation of these unregulated firearms, but it is imperative that Virginia also take action and go further, because this industry is already working to find a way around the new rule. They have promised that they would, and we just saw that Polymer 80, the largest manufacturer of ghost gun parts, has introduced a new frame or receiver that circumvents the new federal rule. This bill will go further than the federal rule and make it harder for this industry to undermine the law and law enforcement. I will note this law will not prevent hobbyists from building guns. They can legally purchase a completed serialized frame or receiver and build any gun they'd like. Brady strongly encourages the committee to report this bill. Thank you so much.
Thank you. Next.
Good morning, Dave Snyder, Falls Church City Council. The city of Falls Church is 7 miles from Washington, D.C., where gun violence is an epidemic. We view this as an important tool among the other pieces of legislation that we support. We've indicated so in writing. And of course, had the bill come up, we would have expressed our strongest opposition to Senate Bill 805. Thank you very much for your consideration as we continue to make Virginia absolutely as safe as possible.
Okay.
Thank you, and we are in support of this and other legislation that we've indicated. Thank you very much, sir.
Thank you. Next.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. This is a great way to help solve more crimes with guns that otherwise would be untraceable. And so we supported the police solving more of gun crimes.
Okay, thank you. Next.
Good morning. My name is Lori Haas. As mentioned, this is a tool for law enforcement to trace firearms. When they find a firearm that doesn't have a serial number on them, the case goes cold. This simply requires a serial number on unfinished parts and receivers. ATF report more and more and more of these ghost guns being found in crimes across the country, including Virginia. We hope this committee will support the bill. Thank you.
Okay, next.
Hi, I'm Peggy Pridemore with Moms Demand Action for Gun Sense in America. We support this bill because it's obvious that untraceable guns are being used in crimes, and this can be changed by you, and you can save lives by supporting this bill. Thank you.
Okay, thank you. Next. Anybody else want to
We have a few speakers on Zoom, Mr. Chairman.
Okay, go ahead.
Jean, you may unmute and speak, and Allison, you will be going next.
Mr. Chairman and members of the committee, my name is Jean Hanowich, and I'm speaking on behalf of the League of Women Voters of Virginia in support of this bill. The League is in support of banning ghost guns as they are unserialized, untraceable, and their purchase does not require a background check. The proliferation of ghost guns is an increasing problem for law enforcement as they are unregulated. The ease of creating a functioning firearm that cannot be traced with only basic tools in under an hour is a threat to public safety. Please vote yes. Thank you for your time.
Okay, thank you. Next. Anybody else want to speak?
My name is,
Go
good
ahead.
morning.
Go ahead.
Good morning, members of the committee. My name is Allison Sheehan from Arlington, Virginia. I am also a Moms Demand Action volunteer and an elementary school teacher and parent. I strongly support this bill to help our communities become safer and to help law enforcement. Thank you very much.
Okay, thank you. Next. Anybody else on Zoom?
There are no more speakers on Zoom, Mr. Chairman.
Is there anybody else who'd like to speak in favor of the bill? All right, at this point, did anybody want to speak against the bill?
If anyone on Zoom would like to speak in opposition, please raise your hand electronically now.
Okay.
Mr. Chairman, Philip Van Cleve, the Virginia Citizens Defense League. We oppose the bill, and this also will do nothing to prevent crime. Maybe after the fact you can trace, but it won't prevent crime at all. Thanks.
Okay. All right. Mr. NRA, how you doing?
Good morning, Mr. Chairman, members of the committee, DJ Spiker, National Rifle Association. We certainly oppose the bill, as Ms. Shart said, from Brady. This goes far beyond federal law. Regulation of firearms is something that we leave to federal law, ATF, et cetera. We believe, especially with this new rule having just passed recently, this is an opportunity for Virginia to stay in line, going broader. There's plenty of litigation out there. There's no reason to go broader just for us to have to walk it back. And as she alluded to, the industry is already staying ahead of the ATF. Virginia legislating it this way. Next year, we'll have a bill dealing with a different type, which is the reason why it's best left to the federal government. Thank you so much.
Okay, thank you. Anybody else want to speak against the bill?
Yes, we have speakers on Zoom, Mr. Chairman.
Okay, go ahead.
Vincent, you may unmute and speak, and Benjamin, you will be going next.
Good morning. I'm Vincent Smith from Virginia Beach. I'm in opposition to this bill. This bill requires registration of a chunk of aluminum that can be milled into a frame. So now I'm going to have to register the heads of my truck's engine, my microwave oven, and the gas manifold of my home's furnace with the ATF. It's ludicrous, it's untenable, and it's a waste of this body's time. I've seen a shovel turned into a firearm frame. M3 machine gun from World War II was made from stamped steel. This bill does nothing to prevent crime. It's just another example of trying to restrict law-abiding citizens from their constitutional rights because punishing criminals is just too darn hard. Thank you for your time.
Okay, thank you. Anybody else want to speak on Zoom?
Hi.
Is this it? No, go ahead.
Yes, my name is Benjamin Campbell. I'm in opposition to this bill. I have one simple question. How on earth would you enforce a bill on how would you enforce banning something that you can't trace? How are we going to find something that is untraceable? And like the last gentleman said, this bill makes it to where that you would have to register a chunk of of aluminum that could be milled into a firearm with the ATF. I do a lot of milling, none on firearms. That would seriously put me in a bind. I'm in complete opposition to this bill. It's absolutely ludicrous. And like the last gentleman said, a complete waste of time and man hours. Thank you.
All right, thank you. Anybody else on Zoom?
Yes, Vic, you may unmute and speak, and Christopher, you will go next.
Thank you. I'd like to point out the people who went for this bill, you didn't see any kind of evidence at all. It was generic, nothing specific examples, with the exception of Senator Evan, from a 2017 one example and a 2019 example, where the kid was even too young, admittedly, to have it anyway. So that was already a violation. Let me make it clear. It is law that we cannot have a gun registry. And that's exactly what this is trying to do. So why are you trying to do something that is illegal? Besides that, gun violence, the problem is the people. It's not the guns. Thank you.
Okay, thank you. Is anybody else on Zoom want to speak against the bill?
Yes, Christopher, you may unmute and speak now.
Good morning. My name is Chris Roll, and I'm from Loudoun County, Virginia. I'm in opposition of this bill. It bothers me to a great extent that in the era of the prosecutors statewide choosing to not go against criminals and actually hold them accountable for their actions, the masses of people in legislatures want to target an object. And it would seem that if you were really serious about violence, you would target the people who are doing the violence and not the tools. As an example, up here in Loudoun County, we had a prosecutor who chose not to prosecute a violent offender using a piece of metal, a hammer, let him out of jail, out of police custody, and then he proceeded to beat his wife to death with a hammer. I think you people have more problems in the era of getting rid of the police and making citizens bigger victims of crimes than going after the people's ability to protect themselves in this era of high crime. So I adamantly oppose this bill.
Okay, thank you. Anybody else want to speak against the bill on Zoom?
There are no more speakers on Zoom, Mr. Chairman.
No more speakers.
Mr. Chair.
Yeah, is there?
I have a motion.
Is there a motion?
I move we report and refer to finance.
Is there a second? Any discussion? All in favor of the motion to report and re-refer to finance, vote aye. All opposed, vote no.
Ayes 9, no 6.
9 to 6, the bill is reported and re-referred to finance. Senator Evan, you have Senate Bill 1192.
I do. This is a ban on public carry of assault-style weapons. They're defined in the bill as a semi-automatic center rifle or pistol with fixed magazine capacity in excess of 10 rounds, a semi-automatic center fire rifle or pistol that can accept a detachable magazine and has one of several characteristics, or a shotgun with a magazine that will hold more than 7 rounds in the shortest ammunition for which it's chambered. Assault weapons, we know, make mass shootings deadlier. A review of mass shootings between 2009 and 2015 demonstrated that in shootings where assault weapons or large capacity magazines are used, 155% more people are shot and 47% more died than compared to those where they were not used. Assault style weapons are used in a majority of mass shootings, and they're used in a higher share of firearm mass murders, up to 57% of all. During the 10-year federal assault weapon ban period, both the number of gun massacres and the number of people dying from gun massacres decreased significantly compared to the 10 years before the ban. This is about open public carry of these weapons, which can be terrorizing for people on the street to see people in their communities, at their farmers markets and other places with those weapons.
Any questions of the patron? Is anybody here who'd like to speak in favor of the bill?
If anyone on Zoom would like to speak in support of this bill, please raise your hand electronically now.
Thank you, Mr. Chair. Dave Snyder, Falls Church City Council. We've actually had this kind of thing occur in our farmers market. It's intimidating, and we urge support for this legislation. Thank you very much for your time and consideration.
Thank you. Yeah. Laurie, next.
Good morning. My name is Lori Haas. We support the bill. These firearms are weapons of war. They're intended to kill as many people in as short amount of time as possible. They have no place on our streets. Public carry of these weapons intimidates families, it scares people, and frankly, it puts our law enforcement at disadvantage. This bill would really help with public safety and give our law enforcement the ease of mind of not seeing these on the streets. They're outgunned too often. So if we can prohibit the public carry, let people own them, let people use them, go to the target ranges, use them on their own property. This is strictly in public. Thank you.
Thank you very much. Yeah, Senator Stanley. Stewart.
That's all right. That's very insulting to me, Mr. Chairman, as much as I respect you, but that's okay.
That's an insult to me,
Realize
too.
it's
So you
early.
take both of us off this early in the morning.
Senator Evan, unless there was a substitute that I didn't get, and I'm reading your bill online, if I read this right, this would even ban carrying shotguns if you were hunting. Do I read that wrong? A semi-automatic shotgun, which is number 4, and it's any public street, road, alley, sidewalk, public right-of-way, or public park, or any public place whatsoever that's open to the public. So you couldn't hunt on public land.
With that specific type of weapon.
With a shotgun?
If it's semi-automatic.
So this would ban a traditional shotgun that we use every day hunting public land. That's semi-automatic.
Answer if you want to make
A pump-action shotgun's semi-automatic.
What we're getting at is what we were
shotgun's
trying to get at with this bill was the public carry in areas where people are in the community going about their business. If the committee wants to make an exception for hunting, that'd be up to the committee.
Well, I'm not going to vote for it anyway, but I thought I would point.
I take your point. I take your point.
You are eliminating hunting on public lands in Virginia if you pass this bill.
Yeah, this is just the specific type of shotgun. And I don't know if council can clarify further or if I'm answering correctly.
Let's go ahead and get speakers first and want to do it later. Okay, we'll do it any amendments later. Go ahead. The lady from Brady would like to say something? Yeah, Senator Evan. You had a couple more speakers.
Sorry.
Brady?
Good morning, Tanya Shard on behalf of Brady. These are weapons of war and certainly not something that everybody should have to face when they're at the grocery store, at the park, or anywhere else. This bill will promote public health and safety and make Virginians feel safer. So we support this bill. Thank you so much.
Okay, next.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. The issue about shotguns for hunting could be solved by using the same definition that's in the law in other places, which prevents the carrying of such shotguns if they have a capacity to hold more than a certain number of shells. And that would solve that issue, not the standard 1 or 2, 3, 4 shells. If you're going out there with a drum magazine or something with a shotgun, or a shotgun that will hold many, many shells, that's not hunting. A double-barrel shotgun is good enough for shooting birds. Thank you.
Okay. Anybody else like to speak in favor of the bill?
There's no one on Zoom, Mr. Chairman.
Anybody on Zoom? Nobody on Zoom? Okay. Do we have an amendment?
I don't think so. I think they speak against.
Okay. Those who'd like to speak against it, please come up.
If any participants on Zoom would like to speak against this bill, please raise your hand electronically.
Philip Van Cleve, VCDL. We oppose the bill. Thank you.
Okay, thank you. Yeah.
Mr. Chairman, members of the committee, DJ Spiker, NRA, while we appreciate the Northern Virginia concerns about farmers markets and parks, that's already embedded into the law. There's certainly opportunities for localities to address this. Localities have, including Falls Church, localities have this authority already. This goes far beyond that. What's good for Falls Church is not necessarily good for Dinwiddie and other parts of the Commonwealth. Thank you.
Okay. All right. Go ahead, sir. Welcome.
My name is Paul Teal from Hanover County. I've hunted for years and years with semi-automatics, the Browning Auto 5, all the different manufacturers. But what we need to keep in mind here is this law will prohibit many gun-free places to hunt. And the real problem with this is the Second Amendment is here to protect the people, not the crazies that want to commit a crime. The Second Amendment is not here to prevent squirrel hunting and rabbit hunting. It's here for a deeper purpose. And I know there are a lot of you all on this panel that know that the Second Amendment was in historically for a reason.
Okay,
Thank you.
Thank you. Anybody else want to speak against the bill? Anybody on Zoom?
Yes, we have several speakers on Zoom, Mr. Chairman.
Go ahead.
Vincent, you may unmute and speak, and Benjamin, you are going to go next.
Good morning, this is Vincent Smith of Virginia Beach. I urge you not to support this bill. SCOTUS has already acknowledged these items to be in common use, and therefore they can't be banned constitutionally, so that this bill would be an overreach of states' ability. Also, to address the previous statement that it's okay to take a rifle to the shooting range, our Constitution's amendments weren't created to protect target shooting. If we can't protect this constitutional right, pretty soon we won't be able to speak our opinion outside our home or inside this chamber. Thank you.
Okay, thank you. Next, on Zoom.
Yes, Benjamin Campbell again. I oppose the bill. I heard one of those in favor say that this makes Virginians feel safer. I'm a Virginian, and I am former personal security. And I feel much safer with people in the populace being able to carry whatever weapon they so choose to defend themselves. Thank you.
Okay, thank you. Anybody else in Zoom?
Christopher, you may unmute and speak, and Vic, you will go next. Christopher, you may unmute and speak.
Sorry. My name is Chris Rowland. I'm in Loudoun County, Virginia. I would like to remind the people on the dais that the federal government gave the Taliban a whole boatload of weapons, to include all the weapons that you're currently talking about trying to get rid of. And I would also like to remind the people in the audience, as well as people on the dais, that the police today currently have these exact weapons, and they can also be fully automatic. So I don't believe that it is within your purview or right for you to take these weapons away from the citizenry, especially since there have not been a scourge of violence against the population. And that can be further demonstrated by what happened in 2019 in Richmond when 50,000 people showed up to peaceably assemble and use this demonstration as why this legislation is not necessary. Thank you.
Thank you. Anybody else on Zoom?
Yes, I would like to correct a couple of things. Is that one, these are not weapons of war. We're talking semi-automatics. Automatic is what you would use for war. It would be, the better thing is that we have people that don't know what they're talking about in terms of guns or things like that. It's pretty obvious here. How about a dialogue between the two so that we can at least get this correct? Because what happens is this, us, the taxpayers, that are constantly paying for the lawsuits that come up because of the Second Amendment violations and everything else is coming up. All that needs to stop. Thank you.
Okay. Anybody else want Zoom against the bill?
There are no more speakers on Zoom, Mr. Chairman.
Mr. Chair,
Yeah, Senator Dees.
I move we report the bill and re-refer it to finance.
Okay, it's been moved. Is there a second? Second. Moved and seconded that the bill be reported and referred to finance. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 9, no 6.
Okay, the motion passes. The bill has been reported and re-referred to finance. Senator DeStep.
Thank you.
You were here earlier. I mean, we had your bill ready to go earlier. Senate Bill 1378.
Mr. Chairman, members of the committee, thank you very much for your time today. The first bill I have up, and I'm going to save you a lot of time today with striking one of the bills coming up, but Senate Bill 1378 is a very simple bill. It basically expands 18.253.1 related to the use and display of a firearm in the commission of certain felonies. Those felonies are committing or attempting to commit murder, rape, forcible sodomy, intimate or animate object sexual penetration as defined by 18.267.2, robbery, carjacking, burglary, malicious wounding as defined in 18.251, malicious bodily injury to a law enforcement officer, aggravated malicious wounding. Let's see, I think that was pretty much it on the crimes. So basically, if you are committing one of the more heinous felonies, then what this bill does is increases the time from, the minimum time from, I believe it's 2 years to 5 years, and then for a second and subsequent offense, from 5 years to 10 years. And Mr. Chairman, members of the committee, if we want to talk about gun control, if we want to talk about crime and crime on the increase in the double digits, the best way to deter crime is harshen the penalties. So, Mr. Chairman, members of the committee, that's exactly what this bill does. It harshens the penalties for the most heinous felonies when you have a concealed weapon and are using it in the commission of those heinous felonies.
We have a sentencing guidelines, right? And sentencing commission that looks at the guidelines.
Yes, sir, we do have sentencing guidelines, and what this does is moves the minimum sentencing guidelines from 3 to 5 years, and for a second and subsequent offense from 5 to 10 years.
Senator Morrissey?
Madam Chair. Mr. Chair.
Senator Morrissey.
Thank you. Good morning, Senator. Senator, good morning.
Good morning, Mr. Chairman, Senator Morrissey.
A central aspect of your bill is creating and increasing the length of mandatory minimum sentences. Isn't that true?
Mr. Chairman, Senator Morrissey, absolutely correct.
In fact, some of the mandatory minimums go to 10 years for the possession of a firearm, do they not?
Mr. Chairman, Senator Morrissey, that's only for second and subsequent offenses for the most heinous felonies and commission of those felonies while using a concealed weapon.
It does go to 10 years.
Senator Morrissey.
Correct, Mr. Chairman. It goes from 5 years to 10 years for the most heinous criminal felonies.
Yeah, Senator Morrissey.
And you're familiar with the concept of a principal in the second degree, correct?
Mr. Chairman, Senator Morrissey, I am.
Right. So if an individual was a principal in the second degree, but did not fire the firearm, didn't possess it, that person could get a mandatory minimum of 10 years for any of those, as you referred to it several times, heinous offense, correct?
And Mr. Chairman, Senator Morrissey, in the commission of these heinous crimes in a second and subsequent offense, so not the first time, a second, third, fourth, or fifth time, in heinous crimes like murder, rape, yes.
Okay.
That's correct.
Final question, Mr. Chair.
Senator Morrissey.
Tell me how your bill would prevent the following scenario, a true one, a real one, that I shared with you and other members on the Senate floor, of a 17-year-old who was picked up by two adults. They went to a party, and 7 people were robbed at that party. The juvenile never possessed the weapon, never knew that the adults had the weapon, but was caught up with them. The two adults got 12 years and 10 years respectively, but when he went to trial, he said, I didn't touch the gun. I didn't know they had a gun. I didn't know anything about it. And they charged him with 7 offenses, and he got 33 years. And the judge said, I don't want to impose this, but it's a mandatory minimum. With your bill, it would now be a 75-year mandatory sentence for somebody who had no idea that his accomplices had a gun, didn't touch the gun, and is 17 years old. Tell me why I shouldn't be concerned, and I ask that respectfully, not in a cheeky fashion, with your bill.
Mr. Chairman, Senator Morrissey, I really don't know the specifics of that case. You're asking me to answer in a case that I'm not familiar with. You're asking me to answer in a case that I don't know all the facts of. And if there was somebody that was just happened to be at a party when something like this happened, I think without knowing the rest of the details, it would be hard for me to try to guess why a specific judge said, well, that guy's related to these two. I don't know what part he played or didn't play in this. You're asking me something that's,
questions?
Fair enough.
I don't have all the facts, so it's hard to guess.
Senator Morrissey.
Senator DeStefano, why can't we let the judges, who we vet quite severely, let them decide what the appropriate sentence is, whether it is as opposed to a mandatory minimum. Let the judge decide, using the sentencing guidelines as help, and who has the experience sometimes of 20 years on the bench, let them decide what the appropriate sentence is, as opposed to the legislature saying you must, irrespective of the circumstances, irrespective of the mitigating factors, impose a 10-year sentence.
Okay, Senator.
Mr. Chairman, Senator Morrissey, I'm not going to get into debate on a gun legislation piece to stiffen penalties on the most heinous felonies we have. I'm not going to get into a mandatory minimum debate and sentencing guideline debate. I'm not here to rewrite the sentencing guidelines. I'm here to debate one specific aspect, which is concealment of a weapon used in the commission of one of our most heinous felonies, and increasing the penalties on those. If you want to stop somebody from stealing, you punish them.
All right, thank
If
you.
you tell a child not to steal a cookie and they steal a cookie and you don't punish them, they'll steal it again. I believe that if you stiffen penalties, that is a deterrent to more criminal activity.
Okay.
Thank you, Senator, and thank you, Mr. Chair.
Senator McClellan.
Thank you, Mr. Chair. I have a question for council. Isn't it the case that for most of the underlying offenses in this code section, that a judge can sentence someone up to life in prison right now?
Mr. Chairman, that is correct.
Follow-up question, Mr. Chair.
Yeah, Senator McClellan.
And in deciding that penalty, they can consider whether during the commission of a crime, someone had a weapon concealed.
That is correct, Mr. Chairman.
Thank you, Mr. Chair.
Okay. Any further questions? Anybody would like to speak in favor of the bill?
If anyone on Zoom would like to speak in support of this bill, please raise your hand electronically. We have several speakers on Zoom,
Okay,
Mr. Chairman.
Okay, go ahead, very quickly.
One moment while I transfer them into the room. Benjamin, once you pop up as a panelist, you may unmute and speak. And Vincent, you're going to go next.
Hi, Benjamin Campbell again. I support the bill. I think we should be stiffening penalties on criminals. And quite frankly, I think it's pretty sickening to watch people defend criminals of the most heinous sort. Thank you very much.
Okay. Next.
Vincent,
Good
you may
morning. This is
speak.
Vincent Smith. Good morning. This is Vincent Smith of Virginia Beach. I'm here to speak in support of this bill because for the first time today, we actually have a bill that treats criminals like criminals instead of treating honest citizens like criminals. Thank you, Senator DeStefano.
Okay. Next
Christopher,
speaker.
you may unmute and speak. And Vic, you will go next.
Good morning, Chris Rowland from Loudoun County. Again, I'm in support of this bill because this is like the previous gentleman said, this is the first bill that you are all talking about that actually does something to make society safer. The biggest deterrent to any kind of crime is to take the people who are doing those crimes and putting them away. Thank you.
Okay. Anybody else want to speak on Zoom?
Yes, I would like to say that it is very disturbing that we will sit here and give a hypothetical, basically one case situation, and instead of looking at the whole repercussions of everything. Women are violated quite a bit. This would help get them to get the justice they need. And it certainly looks like that this group prefers to sit there and make everything they can for criminals to get away with stuff and to keep repeating stuff instead of keeping us safer, which is why so many guns have been sold. It's because of the fear of what's being done, where judges who don't know what they're doing keep letting criminals off with a hand slap.
Okay.
This actually does something to get them.
All right, thank you. Thank you. Is anybody else on Zoom?
There are no more speakers on Zoom, Mr. Chairman.
Would anybody like to speak against the bill?
If anyone on Zoom would like to speak against the bill, please raise your hand electronically now.
Okay, I notice there's over $5.5 million fiscal impact to the state and 6,500 fiscal impact to localities. Okay, is there a motion?
Mr. Chairman.
Yeah, go ahead.
Well, I guess make the motion and I'll speak to the bill.
Senator Stanley.
I'd like to speak to the bill once the motion is
Okay,
made.
Senator Stanley.
I'll make the motion to report.
Mr. Chairman, we have
Substitute motion.
we have a speaker on Zoom.
Who's on Zoom?
We do have a budget.
Francis, once it pops up as a panelist, please unmute and speak.
Okay, very quick, we're about ready to vote. Yeah, give you 30 seconds.
I've got a substitute motion too.
Okay,
Francis, you may unmute and speak.
Thank you, Chairman. I am speaking on behalf of thousands of Virginians. There are over 1,400 in my group alone, and we oppose this. And I just want to say that I do believe that when someone breaks the law, they should pay the consequences. But I don't think that a judge could be a judge if you're telling him you have to give him this. There are all kinds of situations, and it breaks my heart that we as humans can't get along. It's not that I want everyone to be free. I want the judge to be able to do his job and not say, I have to do this. I know that you were just there or whatever, but I have to do this no matter what the circumstances are. Thank you for listening to me, and I oppose this legislation, and I oppose anyone who doesn't oppose it. Thank you.
Mr. Chair. Okay,
Those are all the speakers on Zoom, Mr. Chairman.
Any other speakers?
Mr. Chair.
First of all, are there any other speakers on Zoom?
No, Mr. Chairman.
Okay, all right, is there a motion?
Mr.
I have a
Chairman.
substitute motion.
Substitute motion.
Motion to pass the bill by indefinitely.
Been moved and seconded the bill be passed by indefinitely.
Mr. Chairman.
All in
speak to the
favor?
bill.
Yes,
Speak to the
Senator
bill.
Stanley.
Mr. Chairman, I understand, this is a ritual we do every year. And people who have the right to have an opinion on the Second Amendment come here every year to discuss their views and their beliefs with regard to specific bills. I'm a little stunned here because this is one of those bills that I would think, Mr. Chairman, members of the committee, that we could all come together on. I mean, we all hate crime. We hate when people are raped or murdered using a firearm. There's nobody here who may be in protection of the Second Amendment who believes that's okay. And here is a bill that says if someone conceals a firearm and then commits that murder, that we're going to put them in jail. And we're not going to tolerate it. And maybe it works as a deterrent or maybe it doesn't. But why aren't we all together on this? Because we want to punish the bad guy.
Okay.
With a gun.
The motion has been made and seconded to pass the bill by indefinitely. All in favor of the motion, vote aye. All opposed, no. Vote no. Motion to pass the bill by indefinitely.
Ayes 9, no 6.
9-6. Okay.
Mr. Chairman, members of the committee, I've got two more bills. On Senate Bill 1489, I'm going to strike that bill because we've not been able to get to consensus on that.
Okay, is there a motion that we strike the bill? Is there a motion that we strike the Senate Bill 1486 as a request of the patron? Is there a motion? Is there a second? Been moved and seconded that the bill be stricken, Senate Bill 1489 be stricken. All in favor of the motion to strike the bill, vote aye. All opposed, no.
Ayes 12, noes 3.
Okay, 12-3. The bill is stricken. Okay, Senate
Aye.
Bill 1492, Senator DeStef.
Mr. Chair, members of the committee, I'm going to phone a friend on this one here in a second, but basically what this one does is it protects our state police. And, Mr. Chairman, as Senator Morrissey normally says, here's kind of the situation. Imagine you're a state trooper and you are off duty and going into the office to catch up on your paperwork or to prepare for court. You go into your office and you, of course, as an off-duty trooper, are carrying your firearm and concealing that firearm. Well, in 2020, when we put this bill in place of banning firearms in state-owned or leased buildings, we've made that illegal. And now this officer who's just trying to go in to prepare for court to his office is now breaking the law. So what this does, Mr. Chairman, members of the committee, this fixes that loophole. So as a off-duty officer goes into his office in a state-owned or leased building to catch up on paperwork when he's off-duty or to prepare for a case when he's off-duty, he's not in, he doesn't have to be concerned with breaking the law. And, Mr. Chairman, I think this is common sense, and I'd like to defer the rest of my time presenting this to former Senator Bill Carrico.
Okay.
Thank you.
Senator Carrico, welcome.
Thank you, Mr. Chairman, members of the committee.
We miss you.
I appreciate being missed. I do want to bring and thank Senator Steph. I've done a lot of work on this bill just to narrow it down to the ones that use state property the most, and that's our state police. They're required to go to their area offices to turn in their weekly reports under a time-sensitive manner. All their supplies are held at area offices, which in my case, in my day, I had a pickup truck, so on my off-duty time, I would go to my area office, pick up tires and vehicle supplies for my other colleagues. I was off-duty, which I would have been banned to carry this weapon. And under section, this also applies to retired state police officers that are licensed under the federal law. We qualify each and every year on state property. There was a provision to allow us to go onto that property to qualify, but that was it. But we also have a lot of our retired state police officers that are qualified under this section of the federal code that are part-time employees with the state police just so that they can work to afford their health insurance after they retire. This has become a very concerning matter for our troopers. Because they don't want to run afoul of the law. We don't operate in the gray area. We operate in the black and white. On line 27 says we have to be in our official duty. Our official duty is when we're marked on, in uniform, displaying our badge of authority, and nothing else. Even though we are required to take action if we see something when we're off duty take place. Heaven forbid we be on state property and something happen and we take action, then we fall under a civil liability of carrying that gun on state property.
Senator, this only applies in situations where the state trooper happens to be off duty at the time, or a retired state police officer who is annually qualifies.
Right.
Okay.
Every year we go, we have to be certified. That's under state code. That was brought into place because law officers who are retired or are working were trained to run towards danger, not away from it. And the federal government saw fit that if you are a 10-year veteran or longer, that you could be licensed under the federal law as long as you train.
Anybody have any questions?
Mr. Chairman, I have a question.
Yeah, Senator
Surville.
Thurwell.
Thank you, Mr. Chairman.
And so I appreciate the fact that this has been narrowed, and that's, I think, very useful. But here's what my question is. It seems to apply to any retired state police officer, and I understand you have to do this annual firearm training piece. But what I don't understand is what retired means. It says something in here about, there's a statute it references, but here's what
You have to have left in good standing.
That's what I was getting at. So this wouldn't apply to this catfishing cop guy that just got, his head got picked up or whatever? No?
No.
Okay.
No.
Plus, he wasn't a member of our department when that occurred.
Right.
Any other questions?
Mr. Chairman.
Yeah, Senator who? Okay, Senator McDougal.
Bill, in looking at this, certainly understand what you're trying to do from state police, but our local sheriffs find themselves in that same situation frequently. They have to pick up paperwork at the local training facility. For example, in Hanover, it's a training facility just right around the corner that's state-owned property. Or if they go to some of the hospitals that are state hospitals, that they're picking up blood work from a case or documents and they're not on duty that day, then they would be in violation if they drive their car that had their service revolver into the parking lot. So why wouldn't we include our local sheriff's deputies?
So, Mr. Chairman, members of the committee, I'm not opposed to that. This is a bill. I am working for the Virginia State Police Association. I am.
Say no more. Mr. Chair, tell Mr. Senator Carrico you ought to tell him to get his own bill.
I didn't want to bring that up, but that's, I am not opposed to them being a part of that. I am not opposed to any law enforcement carrying a concealed weapon. I think it is for the benefit of their safety to do so.
Any other questions?
I am just working for the Virginia State Police Association.
Any other
I'm not a
questions
representative any
for
longer.
anybody? Anybody like to speak in favor of the bill?
If anyone on Zoom would like to speak in favor of this bill, please raise your hand electronically. We have some speakers on Zoom, Mr. Chairman.
Okay.
Christopher, once you're promoted to a panelist, please unmute and speak.
Second. Just see if there's anybody want to speak briefly.
Christopher, you may unmute and speak.
Yeah, 30 seconds. Okay.
All right.
Move to close the debate.
Christopher, you may unmute and speak.
Sorry, I would like you to make a friendly motion to expand this to all retired off-duty law enforcement officers, if possible. Thank you. I support this bill.
You're not in a position to make any kind of a motion. Does anybody else want to speak in favor of the bill? The bill's in good shape. I think you're going to keep talking. You may not be in good shape. Anyway.
Mr. Chair, I just have a very tiny technical amendment on line 32 after officer strike somehow as snuck its way into the bill.
Okay, is there a second?
I support that.
All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Is there a motion on the bill?
Move to report.
It's been moved and seconded that the bill be reported as amended. All in favor of the motion, vote aye. All opposed, no. Vote no. Good shape. Way to go.
Chairman, members of the committee, thank you very much.
Way to go, Senator Carrico and Senator Steph. Okay. Now we move on to, Senator Frivola has a bill.
Thank you, Mr. Chairman.
909.
909. Mr. Chairman, this bill does two things. When somebody is the subject of a protective order or has been convicted of an assault and battery of a family or household member, that person then has to transfer or sell or surrender his firearm, his or her firearm. And what this bill says is if the firearm is transferred, the transferee must be at least 21 years of age and not reside with the subject of the protective order or the person who was convicted. And then secondly, the bill says that the person who was the subject of the protective order or the one who was convicted of assault and battery of a household or family member must complete a form that actually tells the clerk of the court the name and address of the transferee or the federally licensed arms dealer or the law enforcement agency who happened to be in possession of the firearm. So this is intended to merely close a loophole in ensuring that the transfer of a firearm, which is already required by law, actually takes place and that there's a record in court. It doesn't change any current statutes regarding who has to relinquish a firearm or the timing of it doesn't do any of that. It merely just closes the loop on ensuring that the transfer takes place.
Okay, is there any question of the patron? Is anybody like to speak in favor of the bill?
If anyone on Zoom would like to speak in
Senator
favor
Sherman,
of this
quick
bill, please
question.
raise your hand
Senator
electronically.
Obenshain has a question.
Just a real quick question. So if the transferee who has registered his or her possession of that firearm subsequently transfers it to somebody else, is there any requirement that is imposed upon him or her to make that transfer?
I do not believe my bill addresses any requirement on the transferee. But
Okay.
Okay, all right. Yeah.
Mr. Chair.
Okay, who would like to speak in favor of the bill? All right, Senator Morsi, do you have a question?
Just real quickly.
Okay.
yes, sir.
Senator Favola, the form that they fill out, and I think it's a very practical component.
That's right.
Is that form done under oath when they give to the clerk that I have transferred it to somebody that's over 21, that's not in my house, et cetera?
I do not believe it is. The intent was, once it's filed with the court, we thought that action was enough to ensure somebody would be truthful.
One question to staff, Mr.
Senator,
Chair. I'd ask staff, would there not be greater teeth and more grit to this bill if that form that was filed with the clerk was done under oath?
Mr. Chair, to answer Senator Morris' questions, yes, it would have greater teeth, but it would also require $50,000, which I'm not sure if the patron has a budget amendment
Thank
for.
you.
Okay,
I will say this was negotiated with the staff of the Supreme Court. We tried to keep everybody on board with the implementation challenges, if any. So,
okay.
Thank you.
Any further questions? Anybody want to speak in favor of the bill?
Good morning, Mr. Chairman, members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We thank the senator for bringing this forward and support this as a measure to support robust and effective implementation and enforcement of the current firearms laws with regards to domestic violence. One of the challenges that we've been facing is we've gone out and done work with communities, training folks on the laws that have passed in the past few years with regards to firearms and domestic violence, is as we've worked with law enforcement, attorneys, and community partners, we have realized that there are some wild inconsistencies in the requirements of transferees for those firearms restrictions. And it's causing confusion in terms of implementation. And so one of the things we've been asked is there a way to bring some of the code sections that currently work with regards to firearms transfers and surrender requirements and bring those areas over into protective orders and domestic violence convictions. So it's bringing the code sections that work from other areas into effect over here. So thank you very much.
All right, next, in favor?
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. The object here is to remove the firearm from the person, not simply to move it to another room in the house, and not to give it to someone who will turn around and give it back to the person who's prohibited the next day.
Thank you. Next.
Hi, my name is Lori Haas. For the reasons stated, we support the bill.
Okay, thank you. Next.
Hi, Liddy Ballard from Brady. This bill is common sense, and we support this bill.
Okay, thank you.
We have some speakers on Zoom, Mr.
In
Chairman.
favor of the bill on Zoom.
Allison, you may unmute and speak, and Jeanne, you will go next.
Good morning again, Mr. Chair and members of the committee. Allison Sheehan here from Arlington, Virginia. And we thank Senator Favola for bringing forth this bill as a member of the local group of moms demand action for gun sense in America. We want to say that according to research by the Research and Policy Division of Everytown for Gun Safety, in states that have laws requiring relinquishment of firearms, there's a 14 to 16% at least lower rate of homicides by intimate partners or domestic violence partners. That may not sound like a lot, but it sure is better than nothing. So this, again, is a common sense effort to address this. Another good example in King County, Washington or Seattle, when they had regional enforcement of their relinquishment laws, it resulted in 4 times more firearms being recovered in these kinds of cases at a 2-year period that was studied from 2016 to 2018.
Okay.
So we strongly support this bill and ask you to think about the 70 women, for instance, just the women per month who are killed by intimate partners. This is one small step to protect them, and the 1 out of 5 victims who are children. As an elementary teacher, that's especially important to me.
Okay,
Thank you.
Thank you. Anybody else on Zoom?
Hello, Mr. Chairman and members of the committee. My name is Jean Hanowich, and I'm speaking on behalf of the League of Women Voters of Virginia. We also support this bill for the many reasons that have already been stated. Thank you for your time.
Thank you. Anybody else on Zoom in favor of the bill?
There are no more speakers in favor of the bill, Mr. Chairman.
Okay. Anybody oppose the bill?
If anyone on Zoom would like to oppose this bill, please raise your hand electronically.
Mr. Chairman, members of the committee, my name is Chris Stone, and unfortunately I have to oppose this, but I think there's an opportunity to fix a loophole, and I think you can do that today. So I'm a victim of domestic violence. I moved to Richmond 3 years ago to remove myself from a situation where I was abused, both physically and verbally. 18 months ago, my wife purchased a firearm. She sent me pictures of the firearm with threatening messages that she was going to come to Richmond to shoot me. So I went to the magistrate's office and I got an emergency protective order. I was required to go back to court 3 days later to get a temporary protective order. Before I went back to court, she showed up at my house with a baseball bat, broke out the taillights in my car, and broke out the windows in the front of my house, and also broke my Ring doorbell. Subsequently, I went back to court. I got a temporary protective order and returned a month later to get a permanent protective order. The judge ruled in my favor. I got the protective order, but even though it's called permanent, it's only good for 2 years. So fast forward a little bit, she actually appealed the protective order. We went to General District Court, and it was upheld, and I got my permanent protective order reintroduced. So my divorce was finalized in August of last year. In September of last year, my wife was supposed to have moved out of our beach house. We were going to sell it, but she set the house on fire, 23 points of ignition. She had surrendered the weapon to her daughter. She fled the scene, came to Richmond, and was hiding out in her daughter's house. The police eventually did find her. She's now sitting in Virginia Beach City Jail. She's accused of felony arson. My fear is that when she gets out of jail, she knows exactly where that weapon is, and she probably will come after me. She has a list of people that have, she wants to harm. It includes 2 judges from the city of Virginia Beach. So I think if you look at the language, it's on line 45 and 46, and if you look at the language that's on line 112 through 115, this allows a person to transfer a firearm to a family member, and I don't think that we should be allowing that. So, thank you for your time.
Okay, thank you very much. So sorry for your story.
We have several speakers on Zoom, Mr. Chairman.
Okay.
Vic Nichols, you may unmute and speak, and Christopher, you're going to go next.
Thank you. Let me tell you some inconsistencies here. First, you want voting at 16. You want to change your sex earlier, but guns at 21. This is, that's part of the problem. There's no consistency here. Second thing, for domestic violence people, what happened if you have kids that are over 18 and under 21 who are living elsewhere and you want to take them to them because you know what? If the person comes after you, they might come after your kids, and at least your kids would have something to protect themselves. The other thing, everyone that I know of is out serving our country. The only one that I would transfer that is over 18, I've got ones under 18 that I know how to respect and handle firearms appropriately. This removes that out of there, but I have an 18-year-old who is not yet enlisted. So explain to me why it is that I wouldn't be able to transfer them to somebody who I actually knows how to respect and how to deal with firearms appropriately. This takes out that avenue for us. That's the problem that I have. Thank you.
Okay, anybody else against the bill on Zoom? Okay, if not,
Christopher, you may unmute and speak.
My name is Chris Rowland, and I oppose this bill for all the reasons the two previous speakers spoke.
okay, thank you. Next.
Benjamin, you may
Anybody
unmute and
else oppose the
speak.
bill?
My name is Benjamin Campbell again. I oppose the bill. My only problem with the bill is that we're supposed to be treating our citizens as though they are innocent until proven guilty. This bill takes and assumes that the other person in the house would break the law and give this firearm to the person who's prohibited from possessing it. This bill takes and makes the other person guilty before they've been proven so in a court of law. We need due process of law.
Okay.
Thank you.
Anybody else oppose the bill?
There are no more speakers, Mr. Chairman.
Is there any amendments? If not, okay, is there a motion? Been moved and seconded to report the bill. All in favor of Senate Bill 909, vote aye. All opposed, vote no. Just got to go to finance. No.
Ayes 9, no 6.
Okay.
Thank you, Mr.
The
Chairman
bill
and
is
members of the
reported.
committee.
Thank you very much. Now we go on to Senator Boysko, Senate Bill 1139. I think there's no other non-member patrons. Okay. Not committee member patrons. Senator Boysko, I think you have a substitute.
Thank you, Mr. Chair. Yes, after discussion with some of our colleagues on both sides of the aisle and working with you directly, we have a substitute.
It's my substitute.
It is your substitute, and I appreciate
And
your
thanks Charles
guidance.
for helping me put it together.
Move the substitute.
Been moved and seconded to report the substitute. All in favor of the motion, vote aye.
Aye.
Aye. All opposed, no. The motion carries. The substitute is before us.
1139.
Charles or Senator, would you like to explain the substitute?
Absolutely.
Charles,
So-
explain it? Okay.
Mr. Chair, the original bill said that a person who does not separate their ammunition and their gun and lock both in a separate container would have a Class 1 misdemeanor. Your substitute that you worked to create says that anyone who possesses a firearm in a residence where a person knows that a minor under 18 years of age or a person who is prohibited by law from possessing a firearm, which would have helped the gentleman who spoke earlier, resides, shall store the firearm and the ammunition for such firearm in a locked container, compartment, or cabinet, and that is inaccessible to such minor or prohibited person, and that would be a Class 4 misdemeanor. It also requires that every dealer shall post in a conspicuous manner at the premises of the dealer notice stating that the new law that I am proposing, any person who possesses a firearm in a residence where a person knows that a minor under 18 years of age or a person who is prohibited by law from possessing a firearm shall lock it in a container, compartment, and it is a Class 4 misdemeanor. And I so move the amendment, in the substitute.
Second, I think we
already did it.
Adopted the substitute.
Okay, thank you.
Any discussion? Anybody in favor of the bill? Anybody against the bill?
And I had a statement that I would like to,
Yeah, Senator Boysko.
certainly. This bill, SB 1139, requires that gun owners lock up their guns when a child, a teen, or a prohibited person will be in the house. As I just said, it also requires that gun dealers post the new law in a public place. Everybody in this room cares about children and safety, and we know that guns are presenting a very serious problem. You just look at last week, a middle school student in Henrico County brought a handgun to his school, and the week before that, we all know about the 6-year-old who brought a gun and shot his teacher. But this is not a unique situation. The data is clear. Access to firearms are directly correlated with an increased risk for suicide and homicide, and availability of firearms for children is associated with an increased risk of unintentional gun deaths. Though mass shootings make up a small percentage of overall gun deaths, nearly 80% of school shooters under the age of 19 use firearms that they got from their homes or from their neighbors or relatives. This is not new information. According to the Center for Disease Control, between 2011 and 2020, youth gun deaths have increased by 129%. 40% of those were suicide. We know that mental health is a big issue. We've got to do something about it. That means, on average, 6 Virginians under the age of 19 die from injuries directly related to firearms. And I've given each of you a list of horrible incidents from 2021 alone. I'm just going to read one of them. On November 30th, 2021, a 3-year-old boy died from a self-inflicted wound after he was shot in the head in Allegheny County. When the deputies arrived at his home, the warrant states that they found a pistol. The child's grandfather told the deputies that the firearm was his and it was supposed to have been hidden under some clothes. 3 adults and several other children were in the home at the time, and during the search, the investigators also found a revolver and multiple rounds of ammunition. I'll let you all read the rest of them because it would take me probably 10 more minutes. But let's just talk about this. Experts agree that CAP, child access prevention laws, can and do reduce firearm homicides and assault injuries. A review by the RAND Corporation, and they take very special care, reviewed 8 different studies published just this month and said there is definitely supportive evidence that child access prevention laws reduce firearm homicides and firearm assault injuries to young people. And I would just like to talk about, the compliance with this law. It would not be any more burdensome than purchasing a car seat. All of us buy car seats for our children when we buy a car and have small children because we know that it's going to save their life if we have an accident. I did a quick search on Amazon. I found a number of different options that are very affordable, and I'm happy to show this to any of my colleagues who have questions or concerns. This is a data-driven bill. This is a reasonable and proven effective step towards preventing these unnecessary deaths of our children and our teens by requiring adults to be responsible and safely store firearms so that they are not accessible to young children and teens or prohibited persons, just like we just heard from, without knowledge and permission of the gun owner. It also preserves clarity that parents can still allow their children to access firearms for hunting. Just like we all purchase and use car seats for our children, we lock up dangerous medicine in our homes. Let's do this together. I urge you to adopt this common sense measure to save the lives of our children by requiring gun owners to be adults. It is up to us to be the adults and protect our children from harming themselves or others. This is a reasonable thing. It takes nobody's Second Amendment rights away. And I ask that you pass the bill.
Bill, it's got to go to finance. Anybody want to speak in favor of the bill?
Mr. Chairman.
Question for the senator. Senator, I've glanced around the room and I've seen a few prosecutors in here, and I'm reflecting back in the early 90s, 3 cases that I prosecuted as a Commonwealth attorney involved a 5, 4, 7-year-old playing with guns, as children do, and finding an open gun and shooting them. One was with a Glock, one was with a 357 Magnum, and those children, the bullet entered their head and the back of their head. There was no back. Yeah. There was no back to it, to the person's head. So I understand the genesis of this bill. The only thing that surprised me about the bill is if we want to really encourage people to do this or maybe have a little bite, is that I was surprised that you only had a class 4 misdemeanor. So if somebody doesn't lock or secure a weapon, another child gets that weapon, fires it at his or her brother, it's a $250 fine. What was the reason for only having a class 4 misdemeanor for not securing a weapon?
Thank you, Senator Morrissey. Chairman Edwards, Senator Morrissey, we have on the books a law for reckless endangerment. So if you leave a gun on your coffee table that is loaded and you know that you've got a small child, that is a clear example of it. And we have laws on the books that can punish the parents here. We want to change behavior. And you know that I have worked on prison reform, and I believe that if we can teach somebody, instead of sending them to prison, we can change behavior and help people move in the right direction. This is a practical and reasonable step. I have been talking with members of the Republican Party, stakeholders, and Senator Edwards specifically to craft this new approach. And Senator Edwards might have some comments later.
Mr. Chair, I
Senator
certainly will
Senator
defer.
Morrissey, go ahead.
Will defer if you have any comments, but at the appropriate time, I have an amendment to line 16.
Well, it's similar to the last paragraph, that every gun dealer has to have a sign to tell people this, because the public doesn't always know this. The idea is to make sure people understand this is the law. You cannot, if you have a minor in the house or somebody's prohibited from having a gun, this is the law. You gotta have it locked up. That's the reason. The idea is to make sure the public is aware. That's the most important thing.
Thank you.
Yeah, Senator Stewart.
Senator Boysko, I understand you want to keep a pistol away from a 6-year-old. I don't think anybody up here would disagree with you. And I don't know if it's still true, but when I was at Parris Island in the Marine Corps, there were people there 17 that had signed waivers to join early. And they were being trained to fight in wars and kill people with very sophisticated weaponry. And they handled it very responsibly. I probably started carrying a shotgun under supervision when I was about 8 years old, 9 years old, and was taught to handle it responsibly. So what's the magic about 18? I mean, they're very responsible people. You can drive a car at 16, and I'd submit that's just as dangerous as a firearm if you want it to be.
Mr. Chair, Senator Stewart, I appreciate the question. We have seen a 40% increase, 129% increase in children under 19 who have died from firearms. 40% of those are from suicide. You can carry, if you have your gun on your person in your possession, that's fine. If you want to sleep with your gun, with your holster, that's fine. But when you wake up and you don't have it on your person anymore, you lock it up. This is common sense, especially if you have somebody who is vulnerable, who is in a bad situation, or you have somebody else in your home, like the gentleman talked about just a few minutes with Senator Favola's bill. These are common sense measures. If you have it on your person and you want to carry it around with you, that's not a problem. The problem is when you are away from it. When you have a child or a teenager who is struggling, we know that brain science, that kids, teenagers do not have fully functioning executive functioning. They do things reactive, they do things impulsively. This is a common sense measure to save lives.
Okay, any other questions?
Mr. Chairman, I have a technical,
Senator,
just a technical amendment. On line 18, for the word carries, substitute is carrying.
So moved.
Okay, change the word carries to is carrying on line 18. There's a motion been made, and who made the motion? Motion's been made and seconded to make that change on line 18. All in favor of the motion, say aye.
Aye.
All opposed, no. Motion carries.
Mr. Chair,
Yes.
I'd make an amendment on line 16, change the digit 4 to digit 1.
Okay. The reason for the 4 is to give notice to the public, because a lot of people don't know this is the law. And that's the reason for the gun owners, the stores having the sign to explain to people. So the motion has been made to send class 4 misdemeanor to class 1 misdemeanor.
Mr. Chair.
Yeah, well, it might change the fiscal side, I don't know.
Mr.
Yeah,
Chair,
Senator McClellan.
can I ask the patron if she supports that amendment?
Mr. Chair, Senator McClellan, my hope is that we're going to get this bill through the Senate and through the House. I believe that if we carry it in the form that you have offered, Senator Edwards, I have a hope that this is something that we can actually get our wonderful and caring Republican colleagues to support. And I at this moment, I'm going to say that I would prefer that we keep it in the form that we have accepted right now.
Yeah, I would agree. Anyway.
Mr. Chair.
Has the motion been made? Go ahead, Senator.
One other line on line 26, that should also be Class 1.
Mr. Chair, what I would suggest is that perhaps if we see unanimous support for this, I will continue to support it as the Class 4. If we don't, then I will definitely support it on the floor to change it back to a Class 1.
Okay.
Mr. Chair.
Yes, Senator McClellan.
I mean, we have a tradition in the Senate of not amending bills in the way that patrons oppose, and I think we should honor that tradition.
This is the first, Mr. Chair, this is the first step in this process.
Mr. Chair.
The motion has been made. Yeah, Senator Morrissey.
Based on Senator McClellan's comment and the comment of the patron, I'll withdraw the amendment, but I would dare say that I'll still be surprised if we have any support among my good friends on the far left, and I use that word respectfully.
They're all left. Okay. All right, we have one motion's been carried, and so the bill is a motion to report the bill as amended and refer to finance.
Mr. Chair,
we have speakers.
We
on
have
Zoom.
some people who wanted to say something
Okay,
also.
go ahead.
If anyone else on Zoom would like to speak in favor of this bill, please raise your hand electronically now.
Hi, I'm Barbara Boardman here for the pediatricians. We just wanted to reinforce the lovely data that Senator Boysko has given us. This is a public health issue. We feel that these issues have been studied scientifically, and these are policies that you can support. A child in a house with a gun without safe storage is not protected. 82% of adolescent firearms suicides involve a family member with a gun. We know about the number of children who are killed unintentionally in Virginia. Parents tell us that a child knows not to touch my gun, but science finds that 75% of children of gun owners knew where the gun was stored, and 35% reported handling the gun without the parent's knowledge. And this was done on little kids, not teenagers. So we know parents want to protect their children, but they need the information. We know kids break rules and do foolish things when parents aren't looking. I've done that. But if that choice involves a gun not stored safely, we know the result of that foolish choice by that child can be totally dangerous, whether they're a little kid or an adolescent who is feeling badly about themselves. So please, we wish you would support this bill. We think it's very important for the children of the Commonwealth.
Okay, thank you. Keep it short if you can. Thank you.
Good morning, Mr. Chairman. Kathy Bircher on behalf of Roanoke City Public Schools. Roanoke City Public Schools believes that expansion of safe and responsible gun storage is an important and key component in school safety and security, and we support the bill.
Good, thank you. Okay, Laurie?
Good morning, Lori Haas. There are so many reasons to support this bill, but I would like to ask you to focus on our schools and what they're going through and what they're experiencing over and over and over again with children. Children are bringing firearms to schools, and our schools have very little means and methods without hardening our schools of doing something about this. Our parents need to lock up their firearms. If you choose to own a firearm and you choose to have it in a home with children, please lock it up. When we've seen 129% increase, let me repeat, 129% increase in children dying from firearms, it's up to this body to do something about that. These are deadly weapons. We're not saying don't own them. We're saying store them responsibly and safely. And we appreciate your support. Please.
Okay, thank you. All right.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. Firearms are the leading cause of death for children under the age of 18 in America. That's something we lead the world in. If we don't do something about that, then we should be ashamed of ourselves.
Okay, thank you very much. Yeah.
Good morning, everybody. Tanya Sharp from Brady. Every day, 8 children and teens are unintentionally injured or killed by a improperly stored firearm. That's because in this country, 4.6 million children live in a home with unlocked loaded firearms. It's past time to create behavioral change so that storing your firearm safely is the norm. Creating standards and a mandate like this is how we do it. We support the bill. Thank you so much.
Thank you.
Good morning. I'm Anastasia Desaro with Moms Demand Action here in the Richmond local group. And I care about this issue because more than 80% of child firearm suicides involve a gun belonging to a family member. Please help keep our community safe by supporting this bill.
Yeah, thank you. Next.
Good morning. I'm Monica Hutchinson, and on behalf of Rise for Youth and the Virginia State Conference of the NAACP, we strongly support this bill. Thank you.
Thank you. Next.
My name's Jennifer Shotwell. I come from Henrico, and my husband teaches at the school that where the gun was found this past Friday. My daughter is also a student there. So as a mother who could have lost 2 people that day because of the carelessness of a parent in our community, I support this bill and strongly encourage you to as well.
Okay.
Thank you.
Thank you. Is anybody on Zoom in favor of the bill? Okay, go ahead.
Jean, you may unmute and speak, and Allison, you are going to go next.
Mr. Chairman and members of the committee, my name is Jean Hanowich, and I'm speaking on behalf of the League of Women Voters of Virginia in support of this bill. For over 30 years, the League of Women Voters has sounded the alarm that the proliferation of handguns and semi-automatic weapons in the United States poses a significant health and safety threat to its citizens. According to the Centers for Disease Control and Prevention, firearms have become the #1 cause of death for our nation's children. This legislation would help protect children from access to unsecured firearms and stress to adult firearm owners the importance of secure storage. Please vote yes. Thank you for your time.
Okay, thank you. Anybody else on Zoom in favor of the bill?
Yes, Allison, you may unmute and speak.
Thank you, Mr. Chairman and members of the committee. Allison Sheehan here from Arlington, Virginia. Strongly support this bill as a common sense measure with measurable and well-respected data to support it. It's time we prioritize the rights of kids to live versus the right of adults to be inconvenienced by some storage laws. Thank you so much for moving this forward.
Okay, thank you. Anybody else?
There are no more speakers on Zoom, Mr. Chairman.
Okay, yeah, all right. Those against the bill, okay? NRA.
If anyone on Zoom would like to speak in opposition to this bill, please raise your hand electronically.
Good morning, Mr. Chairman, members of the committee, DJ Spiker, National Rifle Association. With due respect, the statistics we've heard today, that presumes a world where Virginia doesn't have child access prevention laws, as you've heard some of the supporters do. We do have those laws, and they're being used by Commonwealth attorneys today. Last year alone, that charge, the recklessly endangered, was used 52 times around the Commonwealth. Commonwealth attorneys are using that law. Specific to this bill, just want to point out on lines 14 and 15, inaccessible to a minor makes this bill nearly unenforceable, especially in the world of YouTube videos, gun safes, locked cabinets, doors, etc., which theoretically would qualify under this language, would be rendered null and void because a kid looked up a YouTube video. There's no such thing as inaccessible to a minor. We've seen that in other states, which is why this bill doesn't pass muster. Similarly, changing the definition to 18, this body specifically has rejected that language change 4 years in a row. We'd encourage you to do so again. It's currently 14 in the recklessly endangered statute. We encourage you to uphold that precedent. Lastly, on lines 22 to 27 of the substitute, there's no exemption here for hunting, which the patron specifically included. In that language posted in dealers essentially alludes to that hunting would be banned under the age of 18 by a minor. It does not include the exemptions that were specifically included here and may mislead people at the dealer thinking they may be in violation of law when they would not be in authorizing consent to their child. Thank you.
Philip Van Cleve, VCDL. One size doesn't fit all. We have plenty of teenagers out there that have been raised around firearms. They've been taught to safely handle them. And there have been cases where somebody under 18 has stopped home invasions with the firearm. They had access to it. Sad case in California where they didn't have access because of laws there, and the children were killed with a pitchfork. Also, ammo, locking up ammo. I think people are picturing one little box of ammo is all you've got. You can put that in the safe. When I buy ammo, I go shooting a lot. A lot of people do. I have thousands of rounds. That's multiple boxes. It would take a huge cabinet to lock up all the ammo. I don't see a need to lock up ammo in this, and it's really not practical. We oppose. Thank you.
Okay, next.
Good morning, Mr. Chairman, members of the committee. I'm Pat Webb, VCDL. I'm also a gun store owner, and for 32 years, I ran a country store. And a lot of the people in my neighborhood thought we kept piles of cash at home. So for that reason, my children, when they were old enough and responsible enough, had access to my guns, knew which ones were loaded, because we had a distinct risk of home invasion, and I wanted them to be safe while I was at work next door. This bill would preclude parents from making that decision. I think it would be better served if we focused on both firearm safety education for all, including children in schools, and if we focused on teaching people safe storage habits. If laws changed behavior, we would not have had the massive slowdown and accident on 95 this morning. Thank you for your time.
Okay, thank you. Anybody else against the bill?
Yes, we have several speakers on Zoom, Mr. Chairman.
All right.
Vic, you may unmute and speak, and Benjamin, you're going to go next.
All right, it would be good if we had people that didn't live in rich sections try to make laws for people in the poor sections. Number one, gang members. How much of this stuff is actually gang members doing whatever it is they want to do with guns? They're going to get it. Same thing with committing suicide. The kids can get auto sears. Well, what's stopping anyone else from getting it? It doesn't really matter. At the same time, let me point out the number of times where somebody has actually been saved. In Indianapolis, teen nephew saved his aunt from the sun stomping on her head. A boy age 14 shot a robber who was strangling his mother at the pizza place. In St. Louis, Missouri, a 13-year-old shot his dad to stop him from choking his mom. A Louisiana 12-year-old shot and killed an armed intruder who attacked his mom. A teenage boy shot a man trying to break into the house. We had a 15-year-old boy in Columbus, Ohio, who wounded his murderer, who was 15. We have a Columbus, Ohio girl who was 17 who used a gun to fend off an armed attacker who shot her in the foot. A North Carolina 12-year-old shot an intruder and killed him during an armed robbery. These are all places where kids appropriately handle firearms to protect their family and other types of stuff. Tell me why they should be disenfranchised.
Okay, thank you.
you.
Thank you very much. Anybody else want to speak on Zoom?
Yes, Benjamin, you may unmute and speak,
Make
and
it very
Christopher, you're
quick.
going to go
Just
next.
make it 30 seconds because we understand the issue.
Yes, sir. I just want to note that the Virginia Center for Safety said that we lead the world in gun deaths. We also lead the world in gun ownership, so that would probably make sense. Also, we've talked a lot about vulnerability, but we haven't talked about the vulnerability of my daughter. If she were home alone, she would be vulnerable. And if there were an attacker, there'd probably be a disparity of force. And so if we're talking about vulnerability, we need to talk about it on all fronts. Thank you
very much. Next.
Christopher, you may unmute and speak, and Vincent, you go next.
I'm in opposition of this because how do you envision enforcing this, right? Are we going to have people coming to people's houses checking to make sure that guns are locked up once this bill passes? This is ridiculous.
Okay.
Thank you.
Yeah, thank you. Next. Anybody else?
Vincent, you may unmute and speak.
Good morning. I'd like to point out that not every time someone under 18 touches a firearm, it doesn't always end in tragedy. In 2019, 3 14-year-old girls were home alone. 2 gentlemen showed up and started beating their way into the house with a shovel, and one of them accessed their parents' firearm, loaded it, fired 1 shot, and ran those 2 men off. So I'd like to ask the sponsor and the proponents of this bill, what would you say to those 3 teenage girls had that gun been locked up in a box and they'd not been able to access it?
Thank you very much. Next.
There are no more speakers on Zoom, Mr. Chairman.
Mr. Chair, I have a motion.
Senator Dees.
I'm going to move the report and refer to Finance because the Finance Committee said they wanted the bill.
it's gone from a Class 1 to a Class 4, and so I doubt the finance referral is necessary, but it was still on the list, so I think we have to send it there.
Is there a second?
Second.
All in favor of the motion to report and re-refer the substitute as amended to finance? All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
Thank you, Mr. Chair.
Okay, yeah, thank you, Senator. Senator Morrissey, you got a bill on assault weapons? The Senate Bill 918. 918. Who's going?
Thank you, Mr. Chair, members of the committee. Senate Bill 918 prohibits the sale of an assault firearm and a large capacity ammunition feeding device. The second component of the bill prohibits the carrying of certain shotguns, semi-automatic center fire rifles, and pistols on any public street, road, alley, sidewalks, or public right-of-way, or in any public park, or in any other place or whatever nature that is open to the public. I would,
Mr. Chair, I'd ask a question of staff. Is the definition of this bill like the substitute for my bill, or is it different?
Mr. Chair, the definition is, I'll say, very similar to your bill. There is a minor difference in that I believe your bill has 10 rounds, which picks up the Senator Eben definition, where Senator Morrissey has 12 rounds in his definition for a single-fire pistol. Other than that, the only other distinction is in the carrying of the firearm. Your definition and Senator Eben's definition for the shotgun said 7 rounds of the shortest ammunition, where Senator Morris's bill says 7 rounds of the longest ammunition. Those are the definitional differences.
Senator Morrissey, would you, if we're going to report all these bills out, would you object to trying to make some consistency between the definitions if we amended your bill to make the definition consistent with the other definition?
I would agree.
Mr. Chair.
Senator Deeds, Senator
Peterson. Is there a reason we're not rolling these together?
Can I ask a question?
Yeah, that's a question of staff, I think. Yes, yeah.
Mr. Chair, if to answer Senator Peters' question, why aren't these bills being rolled into each other? I think that's a question for the committee. Someone has to make a motion to roll them into each other.
Okay. All right, which bills are being rolled into what?
Mr. Chair.
Yeah, Senator Peterson.
I think, people can get as much credit as they want. I think Deeds was.
If I can make it easier,
Yes,
Senator
sir.
Peterson, I have no objection to my bill rolling in. As my good friend Linwood Lewis says, everything needs to be said, but not everybody needs to say it.
And I was going to say it would probably save you having to walk over to the other body, so.
So you would roll it into 1382, which is my bill?
I have no objection to doing
Senate
that.
Bill
You become a chief co-patron.
I'll support that motion
I'm
to
going
roll
to take
the two
credit for it
together.
anyway.
Senate Bill
There you go. There you go.
Senate Bill 918 is rolled into Senator Deeds' bill, which is 1382?
1362, I apologize.
1362. Okay, 1362 is on page.
It's 1382.
Okay, yeah.
Numbered wrong.
Yes. Senate Bill 918 of Senator Morrissey will be rolled into Senator Deeds' bill, which is 1382 on page 7.
And Madam Chair, Mr. Chair, and I'll perfect this later, just make me, if we can, chief co-patron on the bill.
Both of them be chief co-patron, okay.
That's going to reduce a lot of what I have to say.
Right.
May I proceed, or do you want to?
Okay.
I will do whatever you want to do.
Let me just say this.
First of all, we're going to roll the bills in. Senate Bill 918 be rolled into Senate Bill
1382.
1382. Is there a motion?
Yes.
Moved and seconded. All in favor of the motion, vote aye. All in favor, opposed, no.
Mr. Chairman.
Okay, with the two co-patrons.
Ayes 14, no 0.
Okay, Senator Oberchain.
Question for any of the patrons. So is it the patrons, plural, intent to adopt legislation that deliberately is in violation of the teaching of Heller and Bruin, the Supreme Court decisions, or is it your contention that this complies with the test established by the Supreme Court of the United States?
Senator Obenshain, the latter. It would never be my intention to, when we have stare decisis has been established, to promote legislation that is inconsistent with any Supreme Court ruling.
Further question, Mr. Chair.
Senator Obenshain.
Is it your contention that, is it your intention that this bill, if adopted, would apply to prohibit persons from carrying these weapons in the places prescribed who endeavored to do so for the purpose of self-defense?
What was the last words?
Does it apply to people who are carrying for self-defense purposes?
No. If you look at the legislation, it allows for, hold on just a moment, please. If you look at lines 53 through 58, it makes for certain provisions that this bill does not apply to, including law enforcement officers, military, people engaged in lawful activities such as hunting or lawful recreational activities.
So would it apply to you or me if we are not hunting but are simply carrying openly and profess our sole purpose for carrying is for self-defense?
Mr. Chair, I think Senator Obenshain's confusing this with with Evan bill that we already passed.
I don't think so.
Which is the open carry bill.
Okay.
Open carry.
Any more
How about
questions?
concealed carry?
Any more questions of the two patrons to this bill?
Yes.
Okay, Senator Obenshain.
Would it apply to me if I'm carrying for open or concealed with the sole purpose of my self-defense?
Well, the answer would be yes, because anybody could say, I'm carrying for self-defense. But what it tries to prescribe, Senator Obenshain.
I get it. That answers my question,
Okay.
because that's the first prong of the Supreme Court's test. The second is there a historical basis to permit this type of broad prohibitions on public carry for self-defense? What is the historical basis?
Okay, sure.
The historical basis in the Commonwealth, the
Yes.
historical basis in the United States.
Historical
Senator
basis in the Commonwealth.
Right. Well, there isn't one, and that is
Thank you.
Senator Obenshain, let me finish my answer, because I've
Go
always
ahead.
given you the courtesy of answering the
Answer-
question.
Just answer the question.
That's the purpose of my legislation.
I understand.
Okay.
And
I mean, we can be civil
which-
with one another.
Any
I
other
understand.
questions?
Yes.
Senator Obenshain.
My purpose in asking that question is that those are the two prongs for determining constitutionality, and your answers to those questions clearly demonstrate that this is unconstitutional under Bruin. So that's my concern about
Mr.
this.
Chair, I
Senator
would,
Deeds.
the historic use test is blown apart with this legislation because assault-style weapons, semi-automatic weapons were not available and not in common use when the history was established, when the Second Amendment was adopted or when the 14th Amendment was adopted.
1791. Okay. Any other questions? Yes, Senator Stanislaw has a question.
Is this similar to the laws that have passed in a lot of the New England states? And the reason I ask that, Senator Morrissey, is that the Second U.S. Circuit, which I think is headquartered in New York but covers New England, have upheld that. And in each of the cases, the U.S. Supreme Court, on an appeal, has refused to take the case. Is this identical to what they've passed in other states dealing with assault-styled or assault weapons?
I would say yes, and I think, Senator Stanislaw, that the reason that the Supreme Court decided not to grant writ in the Second Circuit is for exactly that reason. I do not see, contrary to my good friend Senator Obenshain, that there's a constitutional prohibition.
Okay.
And further, I might add, when this legislation was put forward to Senate Legislative Services, there was no, what we traditionally refer to as a gray sheet that was returned with it.
Okay. Any other questions?
Mr. Chair.
Yeah, Senator Deeds.
But I'd like to go to 1382 if that's what we're looking at now. That, because there were additional changes in the substitute, have they been incorporated already? In the substitute we just adopted?
Mr. Chair, I do have a copy of the substitute that was prepared for 1382 that changes the definition, so if I could pass that out, I think that might be helpful.
Okay, please pass that out. This, I'd ask the committee to adopt this substitute.
Okay. Is there a move? Is there a
This
motion
is
to
your
adopt
substitute, Senator Deeds.
Substitute includes yours, but includes.
All right, we're
Essentially, Senate Bill 918, my bill, is ruled into this substitute.
918?
918 and 13, it says 1362, but it's 1382.
Wait, we've already rolled them
merged,
together.
But we had additional changes.
Okay, so we have a substitute to the merged bill, is that right?
That's it.
Okay, all right, 1362.
It's 1382. It's mislabeled.
Okay. The bill that's labeled 1362 is actually 1382, is that correct?
That's correct.
All right, okay. And so here's a substitute then to the
Mr. Chairman,
merged
move the
bill.
substitute.
Right? The motion
Second.
to adopt the substitute to the merged bill been moved. Is there a second?
Second.
All in favor of the motion to merge the two bills into this new substitute, vote aye. All opposed, no. I think we have to.
No, we don't.
No, we don't. No, okay.
Okay, what this.
All in favor, the motion carries that the bill is a substitute
My
now.
bill was-
Okay.
The substitute language makes one change to basically make this, look at the definition consistent with the Eben bill, which we've already passed. As, in the substitute form, the Deeds Morrissey bill, or the Morrissey Deeds bill does two things. Number one, it says that assault weapons can't be possessed or sold by people under 21 years of age. Number two, it says that weapons as defined in the 1994 federal legislation that passed cannot be, that are manufactured after July 1, 2023. The effective date of the legislation cannot be sold or possessed. Simple.
Well, let me ask you a question, because I have a bill that says you can't purchase a AR if you're under 21. Charles, that's in this bill, this merged bill now, the substitute?
Yes, Mr. Chair. Your bill is just a prohibition on selling assault-style weapons to people under 21, which is part of 1382. And your bill also has been conformed, or at least would be conformed, to the definition in the Eben bill. So it wouldn't conflict with 1382.
Mr. Chairman.
So I'll move then to merge, to roll with Senate Bill 1283 into the substitute that we're talking about now. Is that right?
Second.
Okay, is there any discussion? All in favor of the motion to merge my bill, Senate Bill 1283, into this new substitute bill, which is 1382. Okay. All right, all in favor of the motion, say aye.
Aye.
All opposed, no. Motion carries. Oh, it's got to be recorded. I'm sorry. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no zero.
Motion carries.
May I wrap it up?
In the interest of efficiency.
It's the first bill that there's been more debate on that side than this side. Let me just wrap it up by saying the following. There are people that will oppose this bill, and they are very law-abiding, good, decent, noble people. But I want you to consider this statistic. We continue every year to see an increase in the mass shootings in Virginia and in the United States. Gone from 610 a year to 648 a year to 692 a year. And early this morning, I saw we had another one in Los Angeles. The weapons of choice, the AK-47, the AR-15, and just compare it. 692 mass shootings in the United States in the last year compared to United Kingdom, 1. Australia, 1. Canada, 1. New Zealand, 1. Japan and Norway, 0. So this is what I'm hoping. I'm hoping that this constitutional piece of legislation will pass,
Okay.
I hope that there is an eye towards folks realizing that if we don't do something, these mass shootings will continue unabated. And that's the goal, to stop the carnage in the Commonwealth of Virginia, and I think this bill helps us towards that end. Thank you for your time, Mr. Chair.
Okay, is there any discussion? Yeah, Senator Stewart.
Joe, I heard you say that the weapon of choice in these mass shootings was an AR-15 and an AK-47. Given that, why do you in paragraph 4, line 315 is where first place I see it, ban a shotgun because it has a pistol grip? And they come in two varieties. One is designed for hunting, one's designed for home defense. But yet again, we're banning a shotgun that's regularly used by honest, law-abiding citizens who obey the law every day and don't use it to commit mass murders with.
Thank you for that question, Senator Stewart. And when you asked an earlier patron about a bill dealing with shotguns, I looked over this bill as well. Paragraph, or item number 4, line 40, talks about a shotgun with a revolving cylinder. That's known as a street sweeper.
Look at 315.
Beg your pardon?
Look at line 315.
Oh.
It has
talking about the substitute that's labeled.
the substitute on 315. It has a shotgun that has a pistol grip.
Okay. Let me say this. I don't have that in front of me, but if it reflects or parallels my bill dealing, I mentioned 3 areas with a shotgun. It talked about a semi-automatic shotgun with a folding or telescoping stock, a pistol grip that protrudes conspicuously beneath the action of the shotgun, and the ability to accept detachable magazines.
No, that's it. It's not. You don't have to have
Not that
all.
one.
You don't have to have all.
Okay.
Just a old garden variety shotgun, if it has a pistol grip, and they're designed one of 2 ways, a couple different ways, and they are used for people who hunt and people who use them for home defense.
Okay.
And that's what they're used for.
All right. Let me just say this. My bill, and I'm looking at this on the fly, but my bill created an exception for those hunters, any person engaged in lawful hunting or lawful recreational activities, so that if the bill and the gun that you described is used for that lawful purpose, it wouldn't be in violation of my bill that was rolled into Senator Deed's bill. So that,
Okay.
you're looking at me, does that make sense?
Senator
So my bill is rolled in, so
So
perhaps,
you can possess it if you're going to use it for a lawful purpose.
in my bill you could, I don't know in Senator Deed's bill.
Yeah, Senator Dees.
This bill simply prohibits the possession of certain firearms that are manufactured after July 1 of this date, yes.
My question,
July 1 of this year.
Mr. Chairman, my question is why do we not allow people to have that shotgun? Because I don't think your bill does.
Mr. Chairman, I would say that there's nothing that would prevent you from having one that was manufactured before July 1 of 2023.
Okay.
There's
All
not-
right. Any other questions? Now, where are we? Have we had people speak in favor of the bill?
If anyone on Zoom would like to speak in favor of this bill, please raise your hand electronically.
First of all, we have a bunch of people sitting behind you, Senator Morrissey.
Excuse me.
Yeah, okay. Just say whether you like it or not.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. The issue of shotguns, I think, could be dealt with by maybe changing language. But this bill is not about what color the guns are. It's about what they do. And if it was it would be unconstitutional if it was a bill to prevent anybody from carrying any firearm for self-defense. But this is a bill to limit their ability to kill a large number of people while defending themselves, or whatever they want to call it when they go into a nightclub.
Okay, thank you. Okay, next, Mr. Parker, how you doing?
I'm good.
Good.
Mr. Chairman, I'm Andy Parker. I'm Allison's dad, and I've been before this committee a few times. Weapons of war have no place in this country, and I would say that for those that oppose this bill, it's cowardly, and you're on the wrong side of history.
Okay.
Thank you.
Thank you. Next.
Lydia Ballard from Brady. Assault weapons are firearms designed for offensive attack.
not self-defense, and which are accordingly intended to injure and kill large numbers of people quickly and efficiently. These weapons do not belong in places of peace, and the availability of these weapons by civilians has created a uniquely American problem. It's time to put this to an end. The decade after the federal assault weapons ban expired, the U.S. experienced a 183% increase in massacres and a 239% increase in fatalities. We urge the committee to protect Virginians by banning these weapons of war. Thank you.
Okay, thank you. Next, Lori.
Good morning. My name is Lori House. We support the bill. This simply prohibits the future sale of these weapons. Firearms currently owned that fall under this definition are allowed, and persons are allowed to keep those. And just to make note that Maryland has a ban on these weapons, and that did in fact withstand constitutional challenge in the Fourth Circuit. So thank you. We support the bill.
Okay, next.
Good morning. Jennifer Vanny from Fairfax County. Fairfax County supports this critical tool to enhance community safety measures.
Okay, thank you. Next.
Dave Snyder, Falls Church City Council. We support the legislation.
Okay,
Thank you.
Thank you. Next.
Keith Conway. I support both your guys' bills. I think it's going to save lives. I think it's a great idea. You should do it.
Okay, thank you. Anybody on Zoom?
There are no speakers on Zoom, Mr. Chairman.
Anybody opposed to the bill?
If anyone on Zoom would like to oppose this bill, please raise your hand electronically.
Philip Van Cleve, VCDL. Look, California had such a ban that was upheld by the lower courts. So did Maryland. It went to the Supreme Court. The Supreme Court accepted the cases, vacated them, and sent them back to the states to reconsider in the light of the Bruin decision. So this idea that it's constitutional is not there. So that it is not constitutional. Also, they refer to them as a weapon of war. The Second Amendment gives you the right to own a bearable weapon of war. We totally oppose this. It's unconstitutional.
Thank you. Next. Hey, Charles.
Good morning, Patricia Webb, VCDL, and licensed FFL. I sell guns online. This bill would prohibit me from selling half or more of what I currently sell to anybody in any state, and that would severely damage my business. Also, this bill does not stand up to the constitutionality test. Thank you.
Okay, thank you. Next. Welcome.
Thank you. I'd like to pull out my wallet and show you my concealed carry permit. I took a class for this, and everybody's now required to take a class for concealed carry. I go out to the farm and I practice my pistols. You know, what's the definition of an assault firearm? I carry an H&K with me everywhere I go, and I can load 12 rounds in that clip. So am I automatically considered an assault weapon and I'm breaking the law? That's wrong. And it's not the right thing to do to have police running around all the time and say, oh, your pistol's got 12 rounds in it, or whatever it is. So, every 9mm, 40 caliber, 45, et cetera, that has a clip in it that's over 10 rounds is considered a crime. I don't believe it. Thank you.
Okay, thank you. Next.
Mr. Chairman, members of the committee, DJ Spiker, National Rifle Association. I won't belabor the point on the firearm. I'm doing to point out this does include a magazine limit, again, with a manufacture date post. Magazines themselves are not serialized. There's no way to prove when a magazine was manufactured included. It's an arbitrary limit of 10 per. Just because litigation, I'm not an attorney, I don't presume things are constitutional, unconstitutional before they're litigated. I would point out, I do cover Maryland. The Maryland statute regarding assault weapons ban was at the Supreme Court post-Bruin. It's been remanded back to Maryland. It is currently being litigated by the Maryland Attorney General, and certainly that litigation is ongoing. But there is a recent case specifically post-Bruin that was remanded and is being readdressed. So I just want to point that out. Thank you, sir.
Thank you. Anybody else? Against?
Yes, we have several speakers on Zoom, Mr. Chairman.
Okay, go ahead. Make it quick because I think we understand the issues.
Vic, you may unmute and speak, and Christopher, you're going to go next.
I don't think you understand what it is for the disabled and for women. An AR-15 has more points of contact and is easier to hold than it is a handgun. So right there, you're putting the disabled and women, a lot of women, especially older women, at a huge disadvantage to be able to choose something to be able to protect themselves and their families. And trust me, will in court, we will fight back.
Okay, thank you. Next.
Christopher, you may unmute and speak, and Benjamin, you're going to go next.
I oppose this bill because it's systemically racist, and also if you people were really serious about saving lives, we wouldn't have fentanyl illegals and other things streaming across our border.
Okay, next.
I'm Benjamin Campbell. I oppose this bill. I'm former private personal security. I think that a person should be able to choose what weapon they want to defend themselves with. And when we say that these firearms were not invented at the time of the Bill of Rights being written, neither was the computer. We wouldn't be talking to you like this at that time. So technology increasing doesn't change our rights. Thank you.
Thank you. Anybody else?
Those are all the speakers on Zoom, Mr. Chairman.
Okay, is there a
Mr.
motion? Yes.
Mr. Chairman, everything's been said. I don't need to wrap up.
I move we report and re-refer to finance.
It's been moved and seconded the substitute be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
9 to 6. The bill is reported and re-referred. Senator Norman has a bill he wants to go by for the day. Is that right? Senator Bill 1353. Okay, Senator Norman's bill 1353 will go by for the day. Senator Obenshain, you have a bill 1236, control of firearms by localities.
Mr. Chair, members of the committee, Senate Bill 1236, I think we've already talked about all of the constitutional issues implicated in this bill. This bill deals with the restrictions that we placed a couple of years ago on the possession of firearms in certain public places, parks and streets leading to parks, and festivals and streets leading to festivals, so on and so forth. And I would respectfully submit that, especially in light of Heller and Bruin, that those portions of the statute in Section E, Romanettes 2 and 4 in particular, but also Romanet 3, are just unconstitutional. And at least one court in Virginia has ruled that it is that those are unconstitutional. There is a trial in that case upcoming, but given the constitutional developments, I would respectfully submit that it is important for us to repeal sections Romanet 2, 3, and 4 of this statute.
Okay. Any questions of the patron? Okay,
Mr. Chairman.
Yes, Senator who?
Surville. Thank you. Speaking to the bill really quick. I mean, I appreciate the concern. I don't agree with the Winchester Circuit Court, and disappointed the senator wants to repeal my handiwork from 2020. But I would just
seemed fine at the time.
But Mr. Chairman, I would note that there are historical antecedents for time, place, and manner restrictions on the carry of weapons in public that date into the 19th century, or the 18th century, actually. And there were laws back in England about carrying weapons in places that could inflict terror or fear in people. And I would note that at least partly what motivated the legislation, given that we're making a record back in 2020, was the Unite the Right March in Charlottesville, where people were carrying weapons in the march, and there were shooting exchanged between people, between participants and bystanders in the march itself. And that's one of the reasons we enacted this legislation, to give our localities the option to prohibit that kind of conduct if they wanted to. So I just want to note that for the record. Thanks.
If we have a legislative record, I will gladly expound on that, but I don't think that we do in Virginia.
Mr. Chair.
Okay.
Mr. Chair.
Anybody? Yeah, Senator Morrissey.
Question for the patron. Good morning, Senator.
Good morning again, Senator Morrissey.
One of the mantras of the Republican Party that I really like is that the following, that those closest to the governed govern best. Washington shouldn't be telling Richmond what to do. Richmond ought not to be telling localities to do. Your bill 1236 seems to be inconsistent with that mantra. Can you tell us why Richmond is so, and the legislators here in Richmond should be telling localities what to do when many of us think that those closest to the governed govern best?
Thank you for asking that question. Last I checked, the Republican and Democratic parties' foundational principles were based upon the foundational principles upon which this nation was founded, including the first 10 amendments of the Constitution. And those rights were, at least at one time, deemed so precious that all of us were committed to defending those rights and not picking and choosing which of the foundational principles or which of the rights guaranteed by the Bill of Rights we chose to protect. So I would submit that this is one of those foundational fundamental rights recognized by our founders, which is one of the principles in the Bill of Rights, and no local government ought to be allowed in Virginia to suppress those rights.
Okay. Yeah, Senator Morrissey. Any more questions? Okay. Are those in favor of this bill?
Come on, Mark.
If anyone on Zoom would like to speak in favor of this bill, please raise your hand electronically.
Senate Bill 1236.
Good morning, Mr. Chairman, members of the committee, DJ Spiker, National Rifle Association. 2 quick points, certainly, to Senator Obenshain's point. Right now, there is a patchwork of laws that we warned about 3 years ago, especially in Northern Virginia. With the localities, you cannot follow the law when you drive from one locality to another because the ordinances vary so much. This bill is a step towards remedying that. We warned about it in 2020. Unfortunately, it's come to fruition. Secondly, just to point out for the legislative record, Mr. Chairman, Senator Suravel, there was a law on the books against Charlottesville and open carrying when the Unite the Right in 2017, specifically prohibiting open carry of firearms in exchange within the bounds of the city of Charlottesville. Just to make sure, I wanted to point that out for the legislative record as well. Thank you, sir.
Okay, next, Philip.
Philip Van Cleve, VCDL. We strongly support the bill. Yes, indeed, the Supreme Court of the United States pointed out that places like parks are not somewhere that guns can be banned, as well as permitted events. That was from the Supreme Court. And they also said, as far as government buildings, they had to be sensitive, and not every government building is sensitive. And community and recreation centers are just places people go to do swimming and things like that. That's not a sensitive government operation. So this is, again, this is simply removing things that are clearly unconstitutional and saving the state having to deal with that. Thank you.
Next.
Pat Webb, VCDL, and a longtime resident of Virginia. This bill would put to rights something that was done improperly in 2020. It is clearly against the constitutional rights of Virginians. And it is the state government's duty to make sure that it protects the rights of the individuals that reside and visit in Virginia. So I strongly urge that you pass this out of committee and let it see the light of day on the floor.
Okay.
Thank you.
All right, thank you. Next, if anybody else in favor of the bill, all in favor?
Yes, we have speakers on Zoom.
Okay, go ahead. In favor of the bill.
Diana, you may unmute and speak, and Vincent, you're going to go next.
And
Hi, I'm
Chair,
Diana Howard.
Mr. Chair.
Hello.
Yeah, Senator Obenshain.
I know that there are people who would like online to speak in favor of it, and I would urge them to be brief in their comments, and I appreciate their signing up to speak.
Yeah, 30 seconds each.
Diana Howard, Chair of the Virginia Beach Tea Party. We are in favor of the bill. I can't carry a cop, but I can carry a gun, and I should not have to traverse from place to place and wonder whether or not, when I'm in public, whether I can carry or not.
Okay, next.
Morning, Vincent Smith from Virginia Beach. In response to Senator Surville's statement that there were historical restrictions on carrying a firearm in public at the time of the execution of the Bill of Rights. I would encourage anybody who believes those statements to go back and read the Heller and Bruin rulings and Halbrook's writings. I do support this bill, and I think it should go further and repeal 15.2915 completely. Thank you.
Okay, thank you. Next.
Vic Nichols, you may unmute and speak.
Tell me what right actually is limited by where you live and can be restricted by local governments simply by where you live. You don't see it. It becomes a problem when people are trying to go all the way around the Commonwealth to try and remember 17 different localities out of 194 who wants to do what. Thank you.
Okay, next.
There are no more speakers on Zoom, Mr. Chairman.
Okay, those against the bill. Local
If anyone on Zoom would like to speak in opposition, please raise your hand.
Mr. Chairman, members of the committee, Mark Flynn on behalf of the Municipal League. And the first question is whether this bill is required to make the Virginia law comply with the U.S. Constitution, and say no. Heller, which is still good law, says that clearly supports laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. Not limited. Those were just two examples. And the Virginia Supreme Court, analyzing Heller in 2011 in the George Mason case, upheld George Mason University's regulation, which included while attending sporting, entertainment, or educational events inside or outside. So I would say that in Virginia, certainly it's not unconstitutional to prohibit carrying weapons in a park or on a street when a permitted event is going on. Obviously, the example that comes to mind for me is the July 4th, Highland Park, Illinois. That was a July 4th parade, and had that been in Virginia, had that shooter been seen by a cop, had this law been being used by that city, would have stopped.
Thank you very much. Next, and I'd ask everybody else, limit it to 30 seconds if you could. Thank you.
Good morning, Jennifer Vanny, Fairfax County. We oppose this bill and promote local control.
Thank you very much.
Dave Snyder, City of Falls Church. We had a robust debate before we used this authority, and we have strong support since. In our particular risk context, this legislation is very important to us in order to protect our citizens. Thank you very much.
Next.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. We support the bill for all the reasons given.
Thank you very much.
I oppose the bill.
Good morning, Lori Haas. We oppose the bill. Localities are as close to speaking for their citizens as it gets. The citizens voted these officials into office. A couple of points. You know, the Second Amendment, like other rights, is not immune to regulation. They're just not. There's a lot of things I would want to say maybe in this body, but I'm not allowed to. And number three, Bruin did not opine on locality authority. It didn't opine on that. So we can look to that, and there's much litigation left.
Okay, thank you very much. Next.
Heather Folio with Moms Demand Action. We strongly oppose this bill. This is about safety, not gun rights.
Thank you very much.
Hi there, Tony Sharp from Brady. Localities should have the ability to make sure that their citizens are safe. Both Bruin and Heller identify that there are sensitive places where firearms need not be present. This is simply just enforcing that. Thank you so much.
Thank you very much. Are there people online?
Yes, we have one speaker on Zoom. Jean, you may unmute and speak.
You have 30 seconds, ma'am.
My name is Jean Hanowich, and I'm speaking on behalf of the League of Women Voters of Virginia in opposition to this bill. Each locality should be able to proactively control the safety measures it deems necessary regarding the possession of firearms in locations under its jurisdiction, especially with the proliferation of gun violence. Thank you for your time.
Thank you very much. Okay, do you want to wrap it up, or?
My advocacy and the advocacy of both sides, I know, have had great effect in swaying the members of this committee.
Okay. Are there motions?
I move to report.
Substitute motion.
Second.
A substitute motion takes precedence. Open the roll. A yes vote is motion to PBI.
Ayes 9, no 6.
Okay, ayes 9, no 6.
Mr. Chairman, one more bill, Senate Bill 1225.
Okay, 1220. We were trying to do the gun bills first, but I know you've got a witness that you
I thank you, if you don't mind.
Yeah, okay, that's the last one on your agenda.
Yeah,
It's
Mr.
a bill we
Chairman,
saw last year, I think. It might be different, I don't,
it's not different. It reported out of this committee last year. This has been designated Caleb's Law. You know, right now, we have legislation dealing with protection of unborn children who mothers have chosen to carry. This is not an abortion bill. This is not a pro-life bill. This is a pro-choice bill. It is also a pro-life bill. And we have code sections that criminalize the intentional killing of a fetus, 5 to 40 years. On the books, has been for a long time. Murder of a pregnant woman, 5 to 40 or 10 to 40 years. What we don't have is a code section dealing with either intentional acts committed through heat of passion or through gross negligence like fleeing from the police or drunk driving, in which an unborn child is killed, but the mother survives. And the motivation for this, and I would like to have Taylor Shiflett come, but Taylor was 6 months pregnant, had determined she was carrying this child. She loved this child, was looking forward to giving birth to this child. A fleeing felon was running from the police, and while Taylor was on her way home from work, she was hit at 90 miles per hour by this felon fleeing. Taylor was seriously injured, and her baby died. This creates a felony manslaughter, not of the same magnitude, 1 to 10 years, 1 to 10 years. And the average sentence for manslaughter is somewhere in the neighborhood of 3 years. This is a modest penalty for someone who takes away the life of an unborn child that a parent has determined to give birth to. So if I may, Mr. Chairman, I would
Go
yield
ahead.
to
Yes,
Taylor.
Senator, there's a personal injury case too, right?
Mr. Chairman.
Wrongful death case.
And I thank you, Mr. Chairman. Typically, very seldom is there a meaningful wrongful death case. In this case, it was a fleeing felon, somebody who I don't believe had the proverbial, well, you know what, the window or 2 plug nickels to rub together or any insurance. And moreover, you know, if they had a lot of insurance, how does that penalize somebody for their clearly criminal behavior? It does not.
Okay. Yeah, go ahead, please. Your name again?
Taylor Shiflett. Thank you for allowing me to be here today and provide testimony for my creation. I have been here for the last 3 years, so I'm sure all of you remember who I am, but what I would like to do is let me remind the floor. This was my baby. This was Caleb. Caleb lost his life with an individual with no regard for human life, got behind the wheel intoxicated. Speeding a double yellow line, he crossed over exceeding 90 miles per hour. What happened to Caleb will happen again. And we are playing with fire while arguing over something that doesn't even matter in regards to this bill. Whether you like it or not, my bill is a women's right movement. When you hear those words, I know that you hear, my body, my choice. It was my body, and it was my choice to bring my baby into this world. A choice that I would make 1,000 times over and over again. I cried for that baby. I begged for that baby. Another individual made their choice, and their choice eradicated mine. How is that fair? How is that just? As I've been listening to you all out in the waiting room all day, we keep talking about hypotheticals and possible situations, right? So let's talk about one. Same person, same duration of pregnancy. But let's say they had a complication and they had to deliver early. And unfortunately, they were at a hospital that did not provide any type of services for a NICU unit to a baby that has been delivered early. They would have to transport that baby via NICU ambulance to the nearest surrounding county that could provide care for him. Let's say another drunk driver gets behind the wheel and they hit that ambulance. Now that is involuntary manslaughter. But because the defining factor of whether we can agree or not that they killed somebody is whether he was inside of me or inside of a NICU unit in an ambulance. That fact of whether that life matters or not is completely outrageous. Virginia only has 2 laws pertaining to feticide, and neither one of them could be applied to my child. Depending on the duration of pregnancy that woman has gotten to, will affect that mother's ability to carry again. If far enough along, the chances of having to have a total hysterectomy to save that woman's life increases drastically. These acts of violence have a horrendous high probability of taking that opportunity for a mother to provide a child a life at all. He took everything from me, and the state did absolutely nothing about it. I am not wrong, and I will continue to come here year after year until we can all agree that this is not okay. This is not a bipartisan issue. I need you to fight with me, not against me. Support your mothers and their children, because what happened to my baby is going to happen again.
Okay, thank you very much. Okay, anything else, Senator Obershine?
No, Mr. Chairman.
Okay, all right. Any discussion, any questions?
Mr. Chair.
Yeah, Senator Peterson.
I remember when we passed this statute in 2004, I actually voted for it, and it had to do with the situation involving a former pro football player named Ray Carruth, who actually intentionally killed both the mother of his baby and the baby itself, and that was the situation. It was an intentional act taken against a pregnant woman to terminate her pregnancy and then terminate her life. And because a key part of that intentionality was at the core of the bill, this, however, deals with a situation tragic where someone has acted recklessly, but without knowledge that the person on the other side is pregnant. In fact, in some cases, it might be impossible to know that. And to me, and I don't practice criminal law as much as some of the other folks do, so that would certainly be something that could perhaps be wrapped up in a pre-sentence report or a sentencing hearing, or the effect on the victim, certainly. But to treat it as a manslaughter, when again, there's no knowledge of the person committing the crime, that this fetus exists or that the woman is pregnant. Can you?
Sure.
That's where I'm struggling.
Two things. One is this bill has 2 sections. One deals with intentional acts, okay? Heat of passion. Heat of passion, not the deliberate, premeditated murder of the unborn child, but a person acting in heat of passion commits an act that takes the life of that unborn child. That, it is a deliberate act. Maybe impassioned, but it is a deliberate act. And I would submit that while if it had been the premeditated act, it would call for 5 to 40 years. This calls for 1 to 10 years. And I think it deserves that, 1 to 10 years. Second part of this deals with a willful disregard of the life and safety of another. And in this instance, if Taylor had been killed, it clearly would have been involuntary manslaughter. We've already said taking the life of an unborn child through a intentional and premeditated act is criminal. And it gives either 5 to 40 or 10 to 40. And I would submit that somebody drunk running from the cops should not be able to escape that 1 to 10 year penalty, probably closer to 2.5 to 3 years, just because Taylor lived and the baby died.
Okay. All right. Any further questions? Okay, we've heard this bill before,
and it passed out of this committee before, and I thank the members of the committee.
We appreciate you coming back, and we're so sorry for your tragic situation. Any further discussion?
Move to report.
It's moved and seconded to report the bill.
Yes, go to finance.
It's got to go to finance.
I amend my motion.
Okay. Any other motion?
Move to report and re-refer to, well, actually, I don't want to report it.
So what is there a motion?
Needs to go to finance.
It has been made, Senator
It's been
Norman.
moved and seconded to report and go to finance.
Okay.
That's the motion. All in favor of the bill, vote aye. All opposed, no.
Ayes 6, noes 9.
6 to 9. Okay. Thank you very much. The bill fails. I'm going to try to get rid of all the gun bills if we possibly can today. I have another bill, but it's not a gun bill, and I would like to go forward, It's Senate Bill 898, Senator Stewart's bill. It's concealed handgun permit.
Thank you, Mr. Chairman, members of the committee. Senate Bill 898. This bill just amends the concealed carry training provisions to allow and recognize training courses that are conducted by instructors certified by the United States Carry Conceal Association, or USCCA, or that use their training curriculum. Mr. Chairman, they are a legitimate, well-qualified, and well-recognized organization that does this training, and we just seek to add that into the statute.
Is there anybody in favor of the bill? Yeah, speak up, stand up.
At least one person.
One person.
If anyone on Zoom would like to speak in favor, please raise your hand now.
Mr. Chairman, members of the committee, Trey Adams from McGuire Woods on behalf of the association. The USCCA is a network of 7,000 instructors that are approved in 43 states to provide firearms education. We have about 200 instructors in Virginia, but because of the structure of Virginia law, what we have to do is get approved or certified by the NRA to then turn around and teach our 5-hour certified concealed carry course.
Okay.
The goal of this bill is simply to amend the code so that our certified instructors are qualified to provide that in Virginia without having to use another
Is
organization's
anybody
process.
against the bill? Is nobody, it's been moved and seconded to report the bill. All in favor, vote aye. All opposed, no.
Thank you.
Thank you, Mr.
You're
Chairman.
very persuasive.
Do you want to
Ayes
hear?
15, no 0.
Me or him? Which one, me or him?
Both of you.
Do you want to hear 1103, Mr. Chairman?
Which one's 1103?
No? It was on the docket, that's the only reason I asked.
Huh? Where is it? Workplace. It's not a firearm bill.
Okay.
Okay, we'll come back. Senator Peterson, the firearm industry members, 1167, Senator Peterson.
Yes, sir.
Good morning. Mr. Chair, members of the committee, this is Senate Bill 1167, which basically creates a new code section which has to do with responsible conduct by the firearm industry and liability when they fall short of that conduct. It starts with defining firearms industry and then products, and then talks about reasonable controls which would apply in the marketing and sale of these products, and specifically focuses on products that are sold either to minors or to people otherwise ineligible to own firearms, or specifically those parts which are sold which can convert a firearm, for example, from a single shot or just an ordinary manually operated to a fully automatic, what we sometimes call a SEAR, S-E-A-R, and just says that a firearm industry has to establish reasonable controls. In other words, just a way to verify who is buying, whether or not a straw purchaser is buying, whether or not it's a legitimate consumer on the other end, and take reasonable precautions to make sure that they do not put out illegal products or do not sell products to people that are otherwise ineligible to buy. It doesn't do anything other than what would be normally required by tort law. Now, historically, we have held firearm industry effectively, I don't want to say immune, but we have put a layer of protection between them, typically because, let's face it, once they sell a product into commerce, it usually goes through several pairs of hands, and oftentimes it will be stolen or misappropriated, and that's how it ends up being used in a crime. This does not use that as an intervening cause which can otherwise cut off liability, and I understand that that's a distinction from the common law, and I expect some of my defense colleagues to raise that point. But I think we've seen that in the firearm industry that there is a propensity and an ability for firearms to get into the wrong hands and for them to be misused and mishandled. And this just simply adds a layer of protection for consumers and those people that deal with consumers to make sure that firearms are sold safely. And I think that's really the sum and substance of the bill, and I probably have a couple of witnesses.
Okay, yeah, Senator Short.
Thanks, Mr. Chairman. Chap, I'm just curious, and I don't know the answer to this, and you probably do, but if we were to enact this in Virginia, how does that jive with the Interstate Commerce Act?
Well, it obviously would have to do with a firearm that would be either sold in Virginia or sold into Virginia. I'm not aware of, at this point, and if there's a federal law which might sort of preclude.
What about preemption? That's what I mean when it comes to interstate commerce and preemption. I don't know.
Let me ask you this. If it's a Virginia company selling to a Virginia consumer, it would not be preemption because there's no interstate commerce. If it's an out-of-state company selling into Virginia to a Virginia consumer, then we may have an issue. I can tell you I've had situations with clients where they have purchased a SEAR over the internet, used that to convert a firearm, and in this case, at least in one case, it was a minor and was arrested by ATF. So that would have been an interstate commerce situation, so there might be an issue of preclusion. But again, if it's a Virginia company selling to a Virginia consumer, it would not be.
Okay. Any other questions? Anybody speak in favor of the bill?
If anyone on Zoom would like to speak in favor of this bill, please raise your hand electronically.
Senate Bill 1167, okay?
Hi, everybody. Tanya Sharp from Brady. First, with regards to the Dormant Commerce Clause preemption claims, both those claims have been raised with regards to similar bills in other states and have not been fruitful. Since the passage of PLACA, firearms manufacturers and sellers have been afforded special protections not given to other industries. These protections have often resulted in dismissed cases that drag on for years pending appeals, and have had a chilling effect on cases brought by those harmed by the actions or inactions of the gun industry. And perhaps most troubling is that it has allowed the industry to put profits over people. I want to be clear, this bill doesn't create strict liability or guarantee a favorable judgment. It simply holds the gun industry the same measure as every other industry because no industry should be above the law. Thank you so much.
Thank you. Okay, Mr. Goddard.
Yes. Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill for the reasons given. Thank you.
Okay. Next.
Mr. Chairman, members of the committee, Chris Sigler representing Fairfax County, and Fairfax County also supports this bill.
Okay, yeah. Laurie?
Yes, sir. Members of the committee, we support the bill. Thank you.
Okay, thanks. Okay.
Falls City Council, I think the immunity granted to firearms manufacturers needs to be cut back, and we hope this will do it. Thank you.
Okay. Anybody else in favor of the bill?
There are no speakers on Zoom, Mr. Chairman.
Anybody against the bill? Senate Bill 1167 of Senator Peterson.
If anyone on Zoom would like to speak against the bill, please raise your hand electronically.
Philip Van Cleve, VCDL. The firearms industry is got to be the most regulated industry in this country. In fact, right now, because of the administration the Biden administration, I mean, even minor paperwork mistakes are causing FFLs to lose their license. So again, to me, this is just piling on a highly regulated industry. Thank you.
Okay. NRA, how you doing? Welcome.
Morning, Mr. Chairman. We appreciate the expedited docket today, certainly. We oppose the bill. Thank you.
Okay. Next.
Good morning. As you know, I'm a FFL in Virginia. This bill would increase liability and potentially put a lot of FFLs out of business. In addition, the auto sears are already highly regulated. They fall under the NFA Act, so if it's not a transferable auto sear, then it can't be sold legally. And if it is a transferable auto sear, it requires a substantial background check, a $200 tax stamp. Thank you for your time.
Okay, thank you very much. Anybody else?
Yes, we have one speaker on Zoom. Vic Nichols, you may unmute and speak.
Who on Zoom?
Hi, if we're not going to sit there and do the same thing to the car industry, which also kills people, they make things that kill people. If we're not going to do that to people who create knives or groups that create knives, then we shouldn't do it to the Second Amendment. Let's face it, the bottom part of this is simply to try to restrict more Second Amendment rights, and that's not going to happen. Thank you.
Thank you. There was a man who I think wanted to speak who stood up. If you still want to say something?
Yes, sir. That'd be fine.
You come up here, okay. If you want to come up, 30 seconds.
Thank you. I'd just like to ask a question to the senator and everyone here. How does this liability jive with the drug industry that has killed over 1 million people and 500,000 or 600,000 people, adverse effects to the vax? Yeah. This is as egregious as it can if you think about it. There's a double standard here which needs to be addressed. Okay. And the firearms industry is protected by the Second Amendment. Okay. The drug industry is not protected by anything. They made themselves not liable for putting out those drugs.
Okay, Senator Peterson, anything else?
I want to thank this gentleman for raising a great point. We actually have held the drug industry liable. And I actually represented 3 counties, and I know Senator Norman's law firm represented a number of counties, and we held them liable for recklessly selling opioids and overprescribing them. It's been multi-million dollars to deal with the effects of that. Same thing with the car industry. We have held the car industry liable where they've created an unsafe product. Look, folks, I agree. It's capitalism, and the way capitalism works is you spread the risk to the people that have the ability to avoid it. Gun manufacturers have the ability sometimes to avoid these situations, and just like every other commercial actor, they can be held liable. That's all I have.
Is there a motion?
Mr. Chair, move to report.
Moved and seconded that the bill be reported. Senate Bill 1167. Does it have to go finance?
No, it does not.
No, it does not. All in favor of the motion to report Senate Bill 1167, vote aye. All opposed, vote no.
I do it right here. Never mind.
Senator Boysko? Ayes 9, no 6.
9 to 6, the bill is reported. Mr. Sewell, how quickly can you do this bill?
I think it's pretty simple.
Yeah, okay.
I always do.
Yeah, Senate Bill.
Love you too, Senator Stanley.
1067, Mr. Sewell, substantial risk orders.
So this 1067 basically just clarifies our red flag law, which passed back in 2020. There's now 19 states that have red flag laws, and the federal government just passed actually the bipartisan Safer Communities Act to make federal grant funds available for states to develop and enforce their red flag laws. And they're also supported by 85% of the public in polling, including 78% of gun owners, I would note. Basically, our law, when we passed it, I was really involved in helping Senator Barker clarify his law. It was largely based on the Florida statute. And one of the things we left out from the Florida statute, it was pointed out to me this year, was the series of factors that we asked courts to look at, either they have to consider or that they should consider in evaluating a red flag situation. And basically, I just took the factors from the Florida law and put them in here. And just so it's clear what courts have to look at, I would just note, I think there's some confusion about what kinds of situations our red flag law applies to. We've seen 127 of these red flag orders issued in Fairfax, Hampton's number 2, Virginia Beach is 3. Hanover County is actually number 5 in terms of using the law, but there's about 50 counties that haven't used the law at all yet. And so I think these factors will help people understand the situations for which these red flag orders need to be issued. That's what the bill does.
Is there anybody in favor of the bill?
If anyone on Zoom would like to speak in favor, please raise your hand electronically.
Good morning, Lori Haas speaking in favor of the bill. The law is working. We've seen it working in multiple jurisdictions across the Commonwealth. Circumstances where the law is being used has stopped school shooters, has stopped workplace shootings, has stopped others. In studies, these laws accommodate people in crisis and the types of violence that judges must consider. In this circumstance, Senator Surabel is just expanding upon the types of evidence that a judge must consider. There's not changing the law. These are valuable tools for law enforcement to address situations where a person is at risk, an increased risk of violence. Thank you.
Okay, anybody else in favor? Okay.
Hi, I'm Peggy Pridemore with Moms Demand. I care about this issue because extreme risk laws empower loved ones to work with law enforcement to intervene and temporarily prevent someone in crisis from accessing firearms. I support this bill because it will make the current law more comprehensive by expanding the types of evidence the court can consider when evaluating whether an individual poses a risk of harming themselves or others. I support the bill. Thank you.
Anybody else?
Yeah, we have a speaker on Zoom. Jean, you may unmute and speak.
Okay, go ahead on Zoom.
Mr. Chairman and members of the committee, my name is Jean Hanowich, and I'm speaking on behalf of the League of Women Voters of Virginia in support of this bill for the reasons already stated. Thank you so much for your time.
Okay, anybody else on Zoom?
No more speakers on Zoom, Mr. Chairman.
Anybody oppose the bill?
If anyone on Zoom would like to oppose the bill, please raise your hand electronically.
Good morning, Mr. Chairman. DJ Spiker, National Rifle Association. Certainly oppose the bill. We appreciate Senator Surville bringing up the Bipartisan Safer Communities Act because the federal government, in putting out the standards for that, cited how short our due process is in our current red flag law. We do not give a right to counsel where DOJ said there should be a right to counsel in upholding the U.S. Constitution. Secondly, in amending this to the Florida statute is one of the worst red flag laws in the country. Nearly more than 90% of initial adjudications are then ruled for a permanent basis. There is next to no due process law. The Florida one we have seen is one of the worst in the country. Certainly don't want to emulate it. The last thing I would point out, the expanded criteria also includes any purchase of a gun or any ammunition in the last 6 months gets due consideration. We certainly oppose that as well.
Thank you.
Sorry.
Philip?
Phil Van Cleve, VCDL. New York just, the Supreme Court just struck down their red flag law. And the whole thing is basically unconstitutional. And that's based on the same problem we have. There is absolutely no mental health individual involved in determining if a person is in a mental health crisis. It's just police, a judge, nobody qualified. Supreme Court in New York said no deal. Thank you.
Okay, thank you. Next.
Patricia Webb, VCDL. This law that's currently in existence and this proposed expansion of the law is also in violation of the American with Disabilities Act. I urge you to repeal the law, or not pass this section, and in the future repeal the red flag law to save the taxpayers the expense of defending it, because it will be challenged.
Okay, anybody on Zoom against the bill?
Yes, we have a few speakers. Vic, please unmute and speak, and then Benjamin, you're going to go next.
Yeah, 30 seconds, please.
Yes, when it goes against the ADA, you can better believe we're going to be challenging it. Thank you.
Okay. Next.
Yes, Benjamin Campbell Gun Leather, and again, I was a former private personal security. I just spent the last year of my life fighting protection order of this sort. It's absolutely a violation of my due process of law. We were able to prove that the accusations against me were completely false, and all it would have taken was for them to do a simple background check on me and for them to look at the actual statement against me and all the self-contradicting statements within it. There was no reason I should have spent a year with my due process of law completely violated. I completely oppose anything red flag related.
Thank you. Is anybody else opposed on Zoom?
Mr.
No more
Chair,
speakers, Mr. Chairman.
Okay, Senator Dees.
I move to report the bill.
Second. Then moved and seconded that the bill be reported. Jessica Fines? Yeah.
No.
All in favor of the motion to report, vote aye. All opposed, no.
Ayes 10, noes 5.
10 to 5, the bill is reported. And Senator Deeds, you have Senate Bill
1484.
1484.
And I'll just do it from up here. 1484, on the 13th of November, Devin Chandler, L. Davis Jr., Deshaun Perry were murdered at UVA. Mike Collins and Marley Morgan were wounded. What 1484 seeks to do is remove an exemption we placed in the law, and we made a change in 2021 to prohibit firearms in state-owned buildings and facilities. We included an exemption for colleges and universities. When they searched the suspect's room at UVA, they found a whole bunch more weapons. The suspect's room was on the grounds at UVA. The possession of a firearm that is part of a curriculum or organizational activities such as ROTC is excluded from this bill. Almost all of our colleges and universities already have prohibitions within their regulation, but this would give it force of law. Law enforcement has raised concerns about their ability to respond to situations quickly and appropriately because the restrictions are not in the code. And Chief Longo, who was the chief of UVA's safety and security, is here. I'd like for him to be able to address this bill if possible.
Okay. Yeah. Welcome, sir.
Mr. Chairman, good morning, members of the committee. Thank you for your service to the citizens of the Commonwealth. I know oftentimes it's a thankless job, but I appreciate what you do for us every day. I come before this committee, much like your former colleague, Delegate Senator Carrico said earlier, we deal with black and white in our business. Currently, the law places this prohibition as an administrative policy violation. Administrative policy violations are dealt with by administrators, people in student affairs, people in the president's office, people in facilities management. And they deal with those situations oftentimes in ways where they're untrained, unskilled, not knowledgeable of the law. By making this a prohibition of criminal law, it opens up the full range of investigative tools and constitutional protections that are normally triggered by the criminal investigative process. As I'm sure all of you are aware, Virginia's public higher education institutions already have policies and regulations in place. Yet these administrative policies, as I said, rest with faculty and staff who aren't the most knowledgeable and the best equipped to address matters that have such a direct, and in this case, tragic impact to public safety. When it comes to law enforcement's ability to enforce the law and to ensure public safety for our students, our faculty, and our communities at large, administrative policies and regulations do not carry the same weight as codified provisions that bring the sanction of potential criminal liability. Moreover, the narrow framework of these policies and the limited scope that they have within the context of law further limits their ability to address threats effectively. I believe that codifying this provision in the context of our criminal laws will advance public safety in three important ways. One, colleges and universities could address public safety incidents more effectively by allowing campus law enforcement to leverage the full range of the tools that they have at their disposal when investigating allegations of criminal law, not policy. Among those tools is the ability to seek a search warrant when firearms and other forms of contraband are believed to be unlawfully possessed in university buildings. The authority of government officials to conduct administrative searches is limited and oftentimes left to those who lack the requisite knowledge, training, and ability to carry out those important tasks. Moreover, law enforcement's participation in this form of administrative process is inappropriate and inconsistent with their lawful authority. And lastly, under our existing policies and regulations, there's no legal way for law enforcement to hold on to a weapon that has been found in violation of a university policy unless it is evidence in a criminal investigation, or contraband. As a practical matter, this means that students can readily retrieve weapons after the disciplinary action is handed down, and I think this law would prevent that. I thank you for your time, and I'm happy to answer any of your questions.
Mr. Chairman.
Senator Obenshain.
A question perhaps for counsel. If a student has a firearm or comes to the attention of the university, the student has a firearm in their room in violation of that university policy, is it not possible to prosecute that student for trespassing?
Mr. Chair, to answer Senator Obenshain's question, university policy in and of itself may not be enough, but if the university has promulgated a regulation, that would be sufficient. I know one of the people who spoke earlier mentioned the George Mason case, and that the Virginia Supreme Court dealt with, and basically it said that university restrictions need to have the force of law. So policy in and of itself doesn't carry the force of law, but a regulation would.
Mr. Further question.
Yeah, Senator Obenshain.
So are the universities able to adopt a regulation?
Yes, Mr. Chair, the universities are able to adopt a regulation, and that's what George Mason did.
Okay. Further question,
Senator
and maybe
Obenshain.
either for counsel or Chief Longo.
Yes, sir.
Is it not the case that most, if not all, of the colleges and universities in Virginia's housing contracts contain agreements that the student agrees that their room may be searched?
To my understanding, it does, sir, but not by law enforcement.
Does it prohibit law enforcement from searching a room?
Would be inappropriate for law enforcement to be engaged in the enforcement of a university policy.
How about a university regulation?
I would take the same position, but I would defer to your counsel.
Counsel?
Mr. Chair, I would think that if a regulation was promulgated by the university, that law enforcement could enforce it since it does carry the force of law.
Thank you.
But Senator, I would add that would not necessarily permit law enforcement to conduct a search of a room based solely on the basis of a trespass.
Okay. Anybody else would
Well,
like to speak? Yeah, Senator Deeds.
Mr. Chair, what I would say is that this creates a uniform standard across all of Virginia's colleges, state-owned colleges and universities, and we have an obligation to the parents of the Commonwealth, parents who send their kids to college, to create a safe space. That's what this bill does. It gives the prohibition of firearms on school property, the force of law, and certainly allows public safety officers to engage when a violation does occur.
Okay, any other questions? Anybody would like to speak in favor of the bill?
If anyone on Zoom would like to speak in favor of the bill, please raise your hand electronically.
Liddy Ballard from Brady. I should have mentioned I'm a Virginian, and we strongly support this bill. Thank you.
Okay. Lori?
Good morning. Lori Haas. We certainly support the bill. We certainly support giving law enforcement the tools and the authority and the legal authority they need to conduct their business and to enforce the law and to keep students safe. If law enforcement is asking for this authority in this legal position, I think we need to afford them that position. What happens when perhaps a facilities manager or someone who is tasked with cleaning the dormitories or someone in other situations, they don't have that legal authority, and we need to give it to law enforcement. Thank you.
Okay, thank you.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. We support the bill. I'd like to point out that in this particular case of UVA, the prohibition on firearms on the campus was initially put in place by a board that was meeting prior to the opening of the college. And Thomas Jefferson himself was on that board and agreed to the prohibition of firearms and spirits and alcohol and wine on the campus. So I think we'd be reverting back to a very old institutional setting.
Anybody on Zoom in favor of the bill?
There is no speakers on Zoom, Mr.
Anybody
Chairman.
opposed to the bill? Okay, here we go.
If anyone on Zoom would like to oppose the bill, please raise your hand.
Philip Van Cleve, VCDL. We oppose the bill. Thank you.
Okay, okay, next.
Patricia Webb, VCDL. I opposed this bill. This takes discretion away from the colleges, and there may be instances where they do want to allow firearms on campus and in the rooms. So I suggest that, as suggested before, we leave the discretion to the authority closest to the people affected by it. Thank you.
Okay, anybody else oppose the bill on Zoom?
Yes, Vic Nichols, you may unmute and speak now.
Okay.
Yes, Senator Deeds made the comment about having a safe space on campus. Well, you know, if you're not going to segregate the locker rooms and the like by sex, then what are you worried about the guns for? If somebody is 21 and goes to college, they're eligible to have a concealed carry license. They should be exempted. Thank you.
Okay. Thank you. Anybody else?
There are no more speakers on Zoom, Mr. Chairman.
Mr. Chairman, I move that we report the bill and refer it to finance.
Been moved and seconded, and before that, I'd like to make a statement. As a former law school representative to the University Judiciary Committee, last year in law school, I support the bill. I know how it works, okay? All in favor of the bill, vote aye. All opposed, vote no.
Mr. Chair?
Yeah.
Ayes 10, noes 5.
The bill is passed, reported 10 to 5. It's got to go to finance? Yes. It's got to go to finance. Okay. Thank you. Senator Deeds, got another bill?
I've got 1306 if you like, Mr. Chair.
Let's do that one.
Okay, 1306 was a request for the circuit court judge in Rockbridge County, the city of Buena Vista. Of course, Buena Vista has a circuit court, Rockbridge County has a circuit court, and Rockbridge's circuit court houses in Lexington. The courthouse in Buena Vista is small, and parking is an issue, and access is an issue. And they've had a couple of cases in the past year, jury cases, that involved a real crowding and public safety issue. We've granted other localities the authority to, at the discretion of the judge, to hold cases in nearby courtrooms. And all this bill does is allows the circuit court judge of Buena Vista at his discretion to conduct jury cases in Rockbridge County.
Mr. Chair, unless there's any opposition, I move to report.
Second. All in favor of the motion to report Senate Bill 1306, vote aye. All opposed, no.
Ayes 15, no 0.
I'd like to bring up a bill, too, that needs to go to finance. It's my bill, Senate Bill 940, compensation of court-appointed counsel. We're doubling the size of the court-appointed counsel. Is that right, Charles?
That's correct, Mr. Chair.
Mr. Chair, unless there's any opposition to this, I move to report.
Go ahead. All in favor of the
And
motion?
re-refer?
Yeah, it's got to go to finance. All in favor of the motion to report and re-refer Senate Bill 940 to finance. All in favor, vote aye. All opposed, vote no.
Senator Obenshain? Ayes 15, no 0.
The bill is reported and re-referred. I had a bill, but I'm going to put it off to Wednesday, dealing with the juvenile courts. I know there are people who want to speak in favor of it.
Mr. Chairman?
Yeah, Senator McDougal.
I had 1135, which I think we have peace in the valley with the substitute language that Charles worked out.
1135, Senator McDougal. Want to explain 1135, possession, purchase,
Go
and
ahead.
sale of catalytic converters.
Well, Mr. Chairman, this is Senator Stanley. I had the idea first in 1117, so I guess we got to roll them together.
So who gets the credit?
Well, McDougal's probably not going to have any other bills passed this year, so maybe you should give it to him.
Mr. Chairman, I think Senator Stanley is presupposing this one will make it through as well, but.
He's presupposing he'll have bills to pass.
Okay, want to explain the bill?
Mr. Chairman, we've had a proliferation of catalytic converters being stolen, certainly across the state, but locally. My Sheriff Dave Hines and our Commonwealth Attorney Trip Chalkley are both here in the audience, and we passed legislation last year to try to deal with that situation. Unfortunately, people have found some workarounds. We had one church who has had over $10,000 worth of catalytic converters stolen from vans in their parking lot. What people apparently now have been doing is, instead of going through the normal process, they're advertising to buy them and then selling them out of state and getting around the statute as currently written. So what this would do would make unless you had a new catalytic converter, it was identified as being on your vehicle, or you were a registered scrap materials individual and followed the process that we established last year, then it would have the penalty if you possessed a catalytic converter.
Mr. Chairman, before we get to the substance of the bill, I want to offer a motion that we adopt another substitute on top of this that includes Senator Stanley's 1117.
Yeah, first of all, shall we roll Senator Stanley's 1117 into
Second.
Substitute for to 1135. Have we adopted the substitute yet? I'm not sure we have. First of all, the motion to roll Senator Stanley's bill 1117 into Senator McDougal's bill 1135. Is there a motion to do that?
So moved.
All in favor of the motion, say aye. Aye. I think we got to vote aye.
Mr. Chairman.
Louis.
Okay. The
Ayes 15, no zero.
All right, so now we have 1135, and we have a substitute 1135?
Mr. Chairman.
Yeah,
Serval.
Senator Searle.
Thank you, Mr. Chairman. I got a question for council. So, there was a case about 15 years ago called Commonwealth versus Yap, or Yap v. Commonwealth, where the Court of Appeals held that rebuttal presumptions or presumptions in criminal statutes were unconstitutional, and that the only legal way we could do something like that in the code was to allow or authorize the courts to make a permissive inference. And so since then, I've tried to be more diligent about us not putting rebuttal presumptions in our criminal statutes because they violate due process. Wouldn't this be more appropriate to call the court may make a permissive inference so it's compliant with that?
Mr. Chair, I think that'd be a friendly amendment. I know this was based on North Carolina law, which allows it for a presumption, but I think the patrons would switch it to a permissive inference.
I'd make that motion then, Mr. Chairman.
What'd you say, Charles? I didn't hear you.
What I said was yes.
Okay, so the Senator Searle, do you have a motion?
Yeah, Mr. Chairman, I would just ask, that my motion would be to conform this to make it a permissive inference instead of a presumption.
Is there
No.
amendment? Where's the amendment?
It's on line 24.
On 24. So what you want to do is, I would say, change the word presumed.
Yeah, council needs to play with it some, Mr. Chairman, but we need to say, like, the court or jury or whatever may make a permissive inference if or something like that.
Right. Mr. Chair, this bill does need to go to finance, so the substitute would be made in between here and finance.
All right, we'll deal with the amendment in finance, right?
No.
No.
Oh, you want to do it now? Okay. Well, so like we change the word.
Mr. Chair,
presumed.
I think Senator Serval is
What?
suggesting the amendment be made in concept, that the bill will be published, and if finance has any problems with it, we can further amendment in between finance and the floor if it
Right.
gets there.
That's right.
Second.
Concept. How do we do concepts? But anyway, okay, I think we get the idea. So let's go ahead and adopt the substitute. Do we adopt the substitute? Okay, all right. Now, is there a motion to report and re-refer to finance the substitute to bill?
Mr. Chairman.
Yes, Senator.
I had a motion to amend this to a permissive inference, which was second, and I think we need to vote that motion
Concept.
first.
How do you do a concept?
I'm happy to do it right now if you want to be that specific, Mr. Chairman. We do it all the time.
Just come up with some language or not, one of the two. We don't do concepts.
Okay, I'll do it right now. Come back to me while we take testimony.
Do what? Okay, what are you trying to do? I know we've done concepts theoretically, but
yours?
yeah. we know what you're saying. This, either we pass it the way it is, or we put in a word amendment.
May presume unless the jury believes, unless the evidence,
I'll come up with the language. Just give me a few minutes.
look at my will presumption from last year, Scott.
Got it.
I know we have done it, but it's not appropriate to do. But concept without words, as Hamlet said, what are you reading, Hamlet? Words, words, words. That's how we explain ourselves. We use words, not concepts.
Mr. Chairman?
Yes.
Here's my motion. I'm stealing language from 4.11107, which is the marijuana possession statute in a motor vehicle. And I would move that we strike on line 23, a person who is in possession of a catalytic converter, and change it to say a judge or jury may make a permissive inference that a person who is in possession of a catalytic converter, I'm sorry, we don't need to strike anything. We just need to add a judge or jury may make a permissive inference that a person in possession of a catalytic converter, and then strike the words is presumed. That's what we need to do.
We're putting the first language, new language before the sentence that says the trier of fact may make a may make an permissive inference. Is that right?
Mr. Chairman, I want to steal the language from 4.11107 subsection C, which starts with a judge or jury may make a permissive inference that, which would make it consistent with language that we've approved before.
Second.
That's the language.
Second.
Everybody got it? A judge or jury may
What a
make a
concept.
permissive inference that. Okay, right before, on line 23, all right? All in favor of the motion, say aye. Aye. All opposed, no. Is there a motion that we report the amendment to the substitute to Senate Bill 1135 to finance? Is there any discussion?
Mr. Chairman, unless there's any opposition, I move to report and re-refer to finance.
Okay. The
Mr.
motion is
Mr. Chairman,
yes.
as someone who's had almost a dozen catalytic convertibles stolen, I second that motion.
It's not fun.
Okay, the motion been made to report to and re-refer to finance the substitute with amendment to Senate Bill 1135. All in favor of the motion, vote aye. All opposed, no.
Can you dunk me a yes?
Do you,
Your vote will be noted. Ayes 15, no zero.
okay, 15-0.
There you go.
Okay. Is there anything else we need to go? Senator Peake? Yeah.
I have another bill if you want to take it up
Okay,
today,
what's your bill?
it's 1207.
1207. Well, let's see.
I think that's probably going to be
How long is
accurate.
1207 going to take?
Mr. Chairman, I don't think it's going to take long. I think there's a substitute that
Okay, Senator Peake.
straight.
Well, I tell you what, Senator Peake has a bill with a witness. Do you have a
Okay.
witness?
No.
Okay. Senator Peake, you have a witness. What bill is this?
It is Senate Bill 973,
973.
sexually violent predators who abscond. And so, I don't know, I do have a witness here. I don't know how many are going to be opposed, so I give that to the chair. I just want to point out it's her third straight time that she has appeared on this bill.
Wait, this will be the last one.
So,
Okay. Senate Bill 793.
we're going to go? Okay.
973, rather.
Thank you, Mr. Chair, members of the committee. All right. I'll give you a little background on this. Every sexually violent predator on conditional release must be on GPS monitoring at all times. However, the SVP Act imposes no criminal penalty if the sexually violent predator tampers with or attempts to circumvent his GPS equipment. If the sexually violent predator is on conditional release with a probation obligation, if he cuts off his GPS and absconds, the supervising officer can obtain an arrest warrant immediately. However, if the sexually violent predator on conditional release has no probation obligation, the supervising officer can only obtain an emergency custody order. Because there's no civil order, no warrant can be issued, and so it makes it much harder to apprehend him. As of January 5th, 2023, 34 sexually violent predators on conditional release have absconded. Of those, 30 cut off their GPS equipment. Of those 30, 17 had no probation obligation and were on conditional release cases only. So they are out. They can, an arrest warrant can be issued immediately. If we amend this, it means even if they are not on active probation, but are sexually violent predators with a GPS, the arrest warrant can be issued immediately. So it cuts out a step. And this did happen, and I do have a witness.
Can they be held in contempt of court if this happens? Yeah. Yeah. Senator Dees, you have a question too?
Over what period of time did 34 people abscond?
Come on up. Come on up. I got my expert.
Okay. Yeah. What's your name, please?
Good morning, Chairman and members of the committee. My name is Susan Barr, and I'm the Section Chief of the Sexually Violent Predator Section in the Attorney General's office. And the Attorney General approves and supports the bill. In response to the question, no, I'm not aware of any situation where anybody's ever been held in contempt. It's just routinely the emergency custody orders taken out. That's a civil order, and so there's no arrest warrant that's issued. So nothing is entered because it's a civil order into law enforcement databases.
The question, Mr. Chair, the question I had was, Senator Peake said 34 people had absconded, and I asked over what period of time have you got 34?
Since Senator Deeds, since the inception of the statute, we've had 34 abscond.
So when was the statute?
It was 2003.
Okay.
Mr. Chairman.
And so of those, 29 actually cut the GPS off. One tried to circumvent it. We actually have 2 absconders at the moment. One absconded in December. He has a probation obligation, so we were able to get a warrant, arrest warrant quickly. The other absconded on March 3rd of 2022. He's still on the run. He was a conditional release case only. He did not have a probation obligation. So he had a head start, because what happens is if they don't have a probation obligation and we get the emergency custody order, what probation officers have to do is then wait 3 days for the absconder not to update his sex offender registry, and then they can get a failure to register warrant. So, but that gives them like a 3-day head start. And I would note that, these are high-risk sex offenders who pose a substantial risk to the public. A couple years ago, we had an SVP who absconded, and he went to Charlottesville during the 54 days that he was on the run, and he actually raped a woman in Charlottesville. He was convicted of rape, abduction with intent to defile, firearms charges, and a probation violation. Fortunately, as I mentioned, he had a probation violation, so they were able to get a warrant immediately. But if he hadn't, if it had only been a conditional release case, he would have had a bigger head start.
But Mr. Chair, if he damages property, can't you get an arrest violation for that? If he damages the bracelet or whatever around his neck, the GPS device?
If that hasn't happened, I guess the issue is how do you prove that he's damaged it? Because typically they cut it off and they dispose of it somewhere. So they haven't been successful with that.
Okay. And Mr. Chair, if I may, and just so the people who are on probation, all this does is put the people who have finished their probation on the same status as the people who are still on probation if they cut off their GPS. There's no reason why the people who are not on conditional probation should be treated differently when they cut off their GPS than the others. And that's the extent of this bill.
Okay. Senator Sorrell, do you have a question?
I did, Mr. Chairman.
Isn't that correct?
I was looking at the description of the bill, and it says something in there about eliminating the requirement that an expert witness be designated by the Commissioner of Behavioral Health prior to being able to testify at a PC hearing. Can somebody explain that?
I'd be happy to, Senator. The Virginia Supreme Court in September, in interpreting the Sexually Violent Predator Act, determined in reading several sections in conjunction with each other that the only expert who can testify at a probable cause hearing is the expert that's designated by the commissioner back when the case is before the Commitment Review Committee. That's where the expert is designated. And that poses problems, several problems. And what we're proposing to do is basically to say that any expert who meets the qualifications, which are you're a licensed clinical psychologist or psychiatrist, skilled in the diagnosis and risk assessment of sex offenders and knowledgeable about treatment of sex offenders, and not members of the Commitment Review Committee. Any expert who meets that qualification can testify at a probable cause hearing, because any expert who meets that qualification, whether they're designated by the commissioner or not, can testify at trial. Trial provides that you don't have to be designated by the commissioner, but the way that the statute was laid out and construed by the court, it's 906, which deals with probable cause hearings, says any expert who meets the qualifications in 904B can testify at the probable cause hearing. 904B, as I mentioned, adds that language. It says a licensed clinical psychologist or psychiatrist designated by the commissioner who is skilled in the diagnosis and risk assessment of sex offenders and knowledgeable about treatment can testify at probable cause. We just want to remove the designated by the commissioner and make it consistent with which expert can testify at trial. And if I may, Senator, to tell you what the rationale behind that change is, if only the expert who is designated by the commissioner, and again, that happens before the case ever comes to the Attorney General's office, but if that expert is the only expert who can testify, that constrains the Attorney General's review of the case and essentially makes it meaningless. The statute specifically says it's up to the Attorney General and only the Attorney General to determine what cases to file petitions on. Well, if the Attorney General can't go out and get a second set of eyes and another expert to look at it, and is forever yoked to the expert that was designated by the commissioner, it sort of makes that review meaningless. And essentially, too, it would make the opinion of the expert designated by the commissioner dispositive. It would also prevent, if that's the interpretation, then a respondent would never be able to retain an expert and have him testify at the probable cause hearing. And I guess the biggest problem is that once we file a petition on someone to have them declared a sexually violent predator, let's say the expert dies, and that's happened. We've had that happen with an expert who handled a number of these cases. The expert becomes unavailable. There's no mechanism to go forward with the case because the Attorney General can't get an expert, and there's no mechanism to send it back to the Commitment Review Committee to have the commissioner designate another expert. So regardless how strong the case is for civil commitment of a particular individual, that would be the end of it, because there's no way, if the expert died, there's no way to get another expert on the case.
Mr. Chairman.
Yeah, Senator Sherrill.
So, first of all, I think with regard to this expert issue, we're talking about the probable cause hearing. And so it appears to me, the way the statutory framework operates currently, that the commissioner's designee is sort of the gatekeeper on whether somebody ought to get into the process, not necessarily the Attorney General. And it seems to me that by changing that expert, it allows the Attorney General's office to shop for an expert that more suits their policy objectives. Can you dissuade me of that?
Yes, Senator, I'll try. The expert is designated by the commissioner when, as you mentioned earlier on, when the case is before the Commitment Review Committee. But the Commitment Review Committee, by statute, only makes a non-binding recommendation to the Office of the Attorney General as to whether to file a petition or not. we're not bound by their recommendation. It's non-binding. And the statute provides it's for the Attorney General to decide whether to file a petition. And if we're forever yoked to the expert designated by the commissioner, it's sort of a meaningless review. And I would say that it's not something that the Attorney General's office does frequently, get another expert, but in certain cases, in order for the Attorney General to do a full review, sometimes it is helpful to have a second set of eyes.
Mr. Chairman.
Yeah, Senator Searle.
I mean, it's helpful to get a second set of eyes if the Attorney General doesn't agree with the expert. I mean, it sounds to me like the Attorney General wants to be able to certify more people than perhaps the department's expert does. And so, you know, the Attorney General just wants a different person to be gatekeeper on these things. That's what it sounds to me like. And it's
Let me ask you a question. If the expert dies, can the commissioner get another expert?
No, sir, Senator Edwards. If once we file a petition and we're going forward and the expert dies, that's the end of it. There's no way to get another expert because our office, the Attorney General's office, cannot go out and hire an expert now in light of the Supreme Court's decision, or at least have one who could testify at the probable cause hearing. And there's no mechanism in the statute to send the case back, once it's in our office, to send it back to the Commitment Review Committee for the commissioner to designate a new expert. So you're sort of at a standstill. We can't get an expert. There's no way to send it back to the commissioner to get an expert. So that's going to be the end of the case regardless how strong a case it might be.
How about changing the language that allows the commissioner to appoint another expert?
You need to create a mechanism to send the case back?
Yeah.
Certainly, that would address the one problem posed by that limitation. But again, the statute says, and I was just going to grab the language here. Okay. In 905 of our statute is where it provides the Attorney General with the period of time to conduct its independent review and file a petition. So while if language were added to create a mechanism to send the case back to the Commitment Review Committee for the commissioner to designate new experts, it would address that problem if the expert dies or becomes unavailable, but it doesn't address the problem of essentially constraining the Attorney General's review, preventing the respondent from ever being able to retain an expert for the probable cause hearing, and essentially to still having that opinion, whatever it is, have it be essentially dispositive.
What happens when you say the person not on probation and tampers with it? What other mechanism is it for to deal with the person tampering with the situation, with the GPS?
That's what we're trying to add to the statute, Senator Edwards, is a provision that would make it a Class 6 felony for him to tamper or attempt to circumvent the GPS mechanism.
But it's currently a civil matter, not a criminal matter.
That's correct, Your Honor. And, there are two other provisions that deal with what sometimes people feel like, well, can't this be handled by other provisions in the Act? But there's a provision that says that committed respondents who escape from the custody of the commissioner, if that's validated, they're guilty of a Class 6 felony. Well, they're not committed. If you're on conditional release, you're under legal custody, but you're not committed. And then there's a provision that says if you leave the state without the permission of the court that placed you on conditional release, or if you didn't return when you were ordered to do so, you're guilty of a Class 6 felony. But the problem is you can't prove they've left the state without the GPS mechanism. So that hasn't been an effective tool to try to address that situation.
Mr. Chairman, do we have a case citation for the opinion that was referenced by the Attorney General?
Yes, sir. If I may just 1 second here, I apologize. Okay, it's an unpublished case. It was Galen Michael Boffman versus Commonwealth of...
You've got it.
Oh, you've got it, okay.
Mr. Benjamin, do you have any comments?
Did anybody have any other questions, or?
Any other questions? Is there anybody who's here against the bill? Or
If
anybody in
anyone-
favor of the bill first? Okay.
If anyone on Zoom would like to speak in support of this bill, please raise your hand electronically.
Yeah, go ahead. Commonwealth Attorney?
Good afternoon. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County. And to be brief, the Commonwealth Attorney do support the bill.
Okay, okay. Next.
Good morning, Mr. Chair, members of the committee. I'm Jerry Fitz with the Virginia Department of Corrections, and we also support this bill. We align ourselves with the comments of the patron as well as Ms. Barr from the Attorney General's office. These cases tend to be the most high-profile cases that our officers tend to supervise, and having this ability would really assist us in being able to get folks into custody much faster than we have right now. Thank you.
Okay, thank you. Anybody else in favor of the bill?
Mr. Chairman.
Yes, Senator Sherrill.
Thank you, Mr. Chairman. You know, I don't have a problem with the new felony for cutting the thing off, but I'm still not convinced that this change about this expert stuff is necessary at this point, especially given the fact that the commission isn't even here. I mean, I understand the Attorney General wants more flexibility, but I'm a little leery of advancing that piece of the bill. So in light of that, I would move, and Senator Peterson would second, removing the changes in line 56 from the bill, actually to do that, you can probably just strike everything from lines 12 through 67 from the bill, because none of the rest of that's necessary if we do that.
Yeah.
Mr. Chairman, we still had a speaker on Zoom to support the bill.
We have, Mr. Chairman, we do have someone on video to explain that.
Other people supporting the
Yes.
bill on Zoom.
And to explain.
Carla, you may unmute and speak now.
Good morning, I'm Carla Zarella from DBHTS, and although our agency doesn't have a position on the bill, I do work with SVPs, and I'm here to offer any technical assistance or questions. Obviously, it seems like Ms. Barr has addressed everything. There is one thing I would add, just for people to be aware of. The wait for the 3 days for the failure to appear warrant actually typically ends up being longer than 3 days. So, and I can, one of the examples that Ms. Barr recently just gave to you, one of those failure to appear warrants took 2 months. So just so people are aware that 3 days, although that's the ideal, often we can't get those warrants in 3 days. And I just want to make sure that people are aware of that.
Okay. Anybody else on Zoom in favor of the bill?
There's no one else on Zoom, Mr. Chairman.
Anybody opposed to the bill? Okay.
Senator Sherrill had a motion.
Sure, Senator Sherrill has a motion, yeah. Motion
And
to
just speak
delete
to that motion.
provision.
Well, that is fine. We'll go with that. There's also a companion bill in the House. We'll get you some more information on the expert. So we'll accept and
Okay.
ask you to vote in
That
favor.
motion would involve some changes
Yeah,
to the
with the
title
passing.
and then the removal of
gonna
everything
strike
through line 67 of the bill.
Okay, the motion's been made and seconded. All in favor of the motion that's just articulated, vote, say aye. Aye. All opposed, no. Motion carried. All right, just call the roll then. All in favor of the motion, vote aye. All opposed. All in favor of the motion, vote aye. All opposed, no.
I'll vote no, but it's going to pass. All right, then. So,
Ayes 9, no 6.
9-6. The motion carries. Now, is there a motion on the bill?
move to report as amended.
Move to report and report and re-refer to finance the bill as amended. Just bill, which is Senate Bill, what's the number?
973.
973. All in favor of the motion to report and re-refer as amended, vote aye. All opposed, no.
All right.
Ayes 15, no 0.
Okay, 15-0, the bill is reported and re-referred. And it's now 11:26. How many hours shall we take from now on out? How about none? And come back on Wednesday. I apologize for those who were here on my juvenile justice bill, but we can take that up next time. So all in favor of amending, what I would say is, the Senate Judiciary Committee is now adjourned.